सॉरी फोन पे आ रहा था मैं कहीं।
पटेल शैलेश भाई किशोर भाई।
पटेल शैलेश भाई किशोर भाई।
वकील सी एनबी याग्निक।
वकील सी एनबी याग्निक।
अश्विन सी रामा भाई।
अश्विन भाई रामा भाई।
वकील सी एमआर भट्ट।
वकील सी एमआर भट्ट।
खोड़ाजी डायाजी ठाकुर।
खोड़ाजी डायाजी ठाकुर।
दोबारा सब कुछ अभी रखो।
भरत सी फताजी।
भरत सी फताजी।
अरे आज
भरत सी फताजी।
आनंदी में
आनंदी बेन। जयेंद्र सिंह।
आगे
चिराग दिलीप भाई पटेल।
चिराग दिलीप भाई पटेल।
वकील सी एके आचार्य।
वकील सी एके आचार्य।
स्वप्नेश सी बाबूजी।
स्वप्नेश सी बाबूजी।
वकील सी अमर भट्ट।
वकील सी एमआर भट्ट।
अरविंद भाई गणपत भाई।
अरविंद भाई गणपत भाई। आगे
अमरुद जी मफाजी।
अमरुद जी मफाजी।
वकील सी पीपी पटेल।
वकील सी पीपी पटेल।
ટીઆર પીટી રાવત.
પીટી રાવત એમાં ચેકની અમાઉન્ટ જે પૂરેપૂરી સાહેબ નામદાર કોર્ટમાં જમા કરેલી
वो नहीं तैयार। मूल जो अर्जदार है वो तैयार नहीं है समाधान के लिए।
मैं इसको मिला नहीं हूँ। मैं लीगल में से पहली पेशी तैयार है।
अच्छा आ जाइए तो देखते हैं, अगर तैयार है तो समाधान में
पूरा पेड कर दिया सर। जैसे कोई
वकील सी आरबी सिंगल।
वकील सी आरबी सिंगल।
दीपक मोहन भाई।
दीपक मोहन भाई।
केतन जयंती भाई।
केतन जयंती भाई।
विजय अशोक भाई।
विजय अशोक भाई।
केतन प्रवीण भाई।
केतन प्रवीण भाई।
इसके लिए वो यहीं पर है या कहीं और है? वो भेजेंगे अभी।
ले आप अफजल लाल भाई।
अफजल लाल भाई।
वकील सी अमर भाई।
वकील सी एमआर भाई।
हाँ देखिए
बोलो
लक्ष्मीकांत जीवा भाई।
लक्ष्मीकांत जीवा भाई। फोन कर दिया मैंने ट्रांसफर देना है लेकिन ओगणीस पांच रिपोर्ट आप आप नाम जो करो तो आरोपी सूरत थी आवे છે।
आपका ग्राउंड क्या है? एग्जामिशन रिपोर्ट दी थी, वो रद्द हो गई
तो
थी।
दिया था सर मैंने, और बीमार थे ना तो बोले अनिवार्य कारण से नहीं आ सके, ऐसा रिपोर्ट दिया था मैंने।
बीमार थे तो मेडिकल सर्टिफिकेट देना।
मतलब ये ऐसा नहीं था, बुखार वगैरह था तो वो नहीं कराया।
कोई बात नहीं, सब
और सर मेरा ट्रांसफर हो गया थी लास्ट टाइम पे।
इससे क्या फर्क पड़ता है?
जी सर, अरे कोई नहीं पता था, लेकिन रिपोर्ट दिया था मैंने आपको।
ट्रांसफर हो तो 2-4 तारीख
पर
तक
सर
सही
रिपोर्ट
जानी
तो
चाहिए।
रिपोर्ट तो दिया है मैंने सर।
सर रिपोर्ट का ग्राउंड को जेन्युइन लगेगा तो करूंगा ना। रिपोर्ट
जी
का
सर।
मतलब राइट क्रिएट नहीं हो
नहीं
जाता
सर,
कि
हाजिर
आपने
सर,
अगर 2 लाइन
सर
लिख के दी है तो राइट
नहीं
क्रिएट
सर,
हो गया।
सर हाजिर रखो, सब कोई बात नहीं, रिपोर्ट प्लीज सर। दवा वाटे से मैटर
आपने लिखा क्या था इसमें? बीमार तो लिखा नहीं था।
अनिवार्य कारण से लिखा है मैंने।
बस तो फिर अनिवार्य कारणों से तो रिजेक्ट ही होती है।
जी सर, पर सर हाजिर रखूंगा आपको। जी सर, पहला फर्स्ट टाइम अराउंड है सर।
पीछे बैठिए।
जी सर, सर फर्स्ट टाइम का अराउंड है, पहली बार अभी
सर
तक।
फर्स्ट टाइम मैं मानता हूँ 19/5 को,
जी सर।
जब आपने एग्जामेशन अर्जी दी।
जी जी सर।
उसके बाद डेट लगी होगा 29/6,
अगर सर आप नांदर को छुट्टी पे थे सर में सर।
इसलिए इसको वहां सूरत से पता
नहीं
लगता है।
आए थे सर, आए थे सर, नहीं आते
कहाँ है? हाजिरी तो लगी नहीं,
तो
आए
सर,
कहाँ
छुट्टी
थे?
पे थे आप, वार्ड से चल
पीछे बैठने को बोला है।
जी सर। जी सर।
सर स्टाफ तो यही था, रोज
जी
काम तो हुआ।
जी सर, वार्ड चल रहा था सर, तो आप थे नहीं हाजिर सर। जी सर।
ये अरेस्ट कर लेते।
जी सर।
कौन? आप कर सकते हो भाई
नहीं आपसे सर,
शुक्ला जी?
नहीं नहीं सर, चार्ज में
हाँ,
से ले सर।
मैंने कहा अरेस्ट कर लेते,
नहीं
आप कह
सर,
रहे हो
चार्ज
हाँ।
में से ले जाता सर, चार्ज में ले जाता सर।
हाँ?
चार्ज में ले जाता सर।
हम्म।
सर फर्स्ट टाइम बात सर, बाजे रखा सर लेकिन।
20/5 से लेकर के 28/7 तक ये कहाँ था?
सर सूरत में से बारिश था, सूरत में बरसात का मौसम, बारिश बहुत है, घर में पानी भर गया था सर।
20/5 से
बीस
सूरत
बात
में
नहीं,
पानी
उसके
भरा
बाद में
हुआ है?
सर, उसके बाद में सर।
सर अभी तो लास्ट वीक भरा है।
हाँ सर, 19 29।
20/5 से पूछ
जिस
रहा हूँ, 20 मई से लेकर कहाँ था?
मौसम की साइड पे थे।
फिर साइट पे जा सकते हैं, वारंट कैंसिल नहीं हो सकते ना।
नहीं सर, बोला मैंने, तारीख क्या नाम, सारे के बाद नहीं है।
सर आपने बोला तो फिर अब मैं कुछ नहीं कर सकता ना उसमें। आप इसको बुला नहीं सकते बिना तारीख। आप
नहीं
कह
सर,
रहे हो
आएंगे
तारीख
सर,
पे
आज
आना
सर
तभी
रेगुलर सर,
देखेंगे।
रेगुलर
ठीक है,
फर्स्ट टाइम
तारीख पे तो मैं ही देख रहा हूँ।
सर रेगुलर आज फर्स्ट टाइम का अवार्ड है सर, इसलिए सर।
सर मेरे पास 2 तारीख लगी है, दोनों पे
जी
नहीं
सर।
आया।
जी सर।
रेगुलर कौन सा होता है?
सर आपकी
फिर
तरफ
रेगुलर आता है हर तारीख पे।
पर सर रेगुलर आज रखूंगा सर, अभी आप एक
सर
बार
वो
वापस करिए सर।
मेरे को पता नहीं ना फ्यूचर में क्या होगा।
जी सर।
मुझे तो अभी जो इसमें है वो पता है, फ्यूचर तो मैं देख नहीं सकता।
जी सर, पर आज रखूंगा सर मैं, इनका फर्स्ट टाइम का अवार्ड है, प्लस भी सर अवार्ड है नहीं इनका अभी।
सर
पहली
दो
बार
तारीख दोनों पे एब्सेंट।
आज सर पहली बार के अवार्ड है,
आप
अभी आपको
कहो
रिकॉर्ड
हमेशा
लिख दिया
आता
सर।
है, मैं कैसे मान लूं?
सर पहली बार का अवार्ड है सर, मुद्दा मुद्दा माल पे मैटर
यही तो
करते हैं
चक्कर
सर।
है।
सर हम तो सर आज रहते हैं सर।
प्रॉब्लम यही है
सर हम लोग तो आज रहते हैं सर, हम लोग
कि आपकी बात मान के कोई
जी सर,
वारंट नहीं
नहीं
करते,
नहीं सर,
इसलिए
हम
आप
लोग
कभी
तो आज रहते
बुलाते
हैं ना
नहीं।
सर,
पहली बार वारंट हुए हैं।
हम लोग एक्शन नहीं देते सर, आज रहते हैं हम, आज नहीं हो सर, बोले हम तो आज रहते हैं
जो
ना,
एग्जामेशन
हमारी
दिया है वो
हमने
देखी
बातें नहीं है
मैंने।
सर, तो फिर
जो एग्जामेशन दिए मैंने देखी।
तो सर वो हमारा सर, हम आज ही हमारे कोई ग्रेजुएट सर देखिए, हमारी भी ग्रेजुएट नहीं है, हमारी वकील की भी। सर प्लीज सर, रिक्वेस्ट सर।
देखते हैं।
जी सर।
कमलेश रावजी भाई, कमलेश रावजी भाई, रावजी भाई मावा भाई, रावजी भाई मावा भाई।
हाँ जी, सारे हैं।
हाँ सर।
कमलेश भाई, रावजी भाई, सविता भाई, अजय, विनोद भाई, रबी भी है।
इसमें रिपोर्ट नहीं है ऐसे।
कैसे भी शादी करेंगे कैसे भी तो।
तो बोलो ना पीआई को लेके आए तो पीआई को नोटिस करो। 2 साल से ऊपर हो गए, रिपोर्ट ही नहीं आई। 10/9।
किरण जी रामा जी, करण जी रामा जी, आनंद जी लाल जी, आनंद जी लाल जी, सीमा बेन रमेश, करण जी, आनंद जी, किंजल बेन चेतन, किंजल बेन चेतन भाई,
ठीक है, अभी लेते हैं, पंडित जी आ जाए।
आकाश कनू जी, आकाश,
अजय।
बड़ी आकाश कनु, आकाश कनुजी, अजय सिंह विक्रम सिंह, अजय सिंह विक्रम सिंह, कपिल बाबर भाई, कपिल बाबर भाई, अजय अजय सिंह,
वो आ रहा है।
दिव्यराज सिंह महिपत सिंह, दिव्यराज सिंह महिपत सिंह,
इंग्लिश में नहीं। 2025 के केस में भी तक नहीं बुलाओ इनको, बैठो बुलाओ। लिस्ट में कहते हैं जी को पूछो, अगर उनके पास आ गई है तो आज फाइल करें, नहीं तो इसको बुलाओ।
राजेश भाई, उसमें बप्पू विखार भाई, राजेश भाई, चित्र भाई, सब आरोपी
क्या हुआ, है क्यों नहीं
से
सर, क्या हुआ है वो लिख दो ना इसमें।
वायरल।
हाँ, लिख लो वायरल। सब्जेक्ट प्रोफाइल में हाँ। भाई, पंड्या जी आ जाए, जरा लिस्ट का देख लें।
तुषार रमेश भाई, तुषार रमेश भाई,
सर परम देसाई, परम देसाई 31 छह तुषार।
आई जस्ट
दो दिन बिना दूर कैसे हैं।
सर, मैं रिक्वेस्ट करने वाला था कि 2 दिन बाद आज मुंबई में आ जाएगा परसों। सोडा
मुंबई में है?
मुंबई में
कल बारिश हो जाएगी वहाँ।
नहीं नहीं सर, आ जाए। मैंने पहले
फिर
किया
कहोगे परसों नहीं आया।
31 है, 1 तारीख को सर कोई भी बोला था आ जाएगा।
ठीक है, 31 से बुला लीजिए।
प्रॉब्लम
राहुल भाई वीरेंद्र भाई, राहुल भाई वीरेंद्र भाई, मुकेश कुमार प्रकाश राज, मुकेश कुमार प्रकाश राज, समीर भाई भरत भाई, समीर भाई भरत भाई, नहीं बात नहीं पण हां एक ईमेल आहे कोई राहुल
क्लियर तो हूँ पहले।
हाँ
राहुल जैन तो यही होगा नंबर 1।
हाँ हाँ राहुल
आरोपी घर बैठे मेल कर रहा है क्लब पर, तो ये क्या तरीका है। क्लियर तो हूँ।
पीएम के लोग
हम्म।
वकील श्री आरडी जानी, वकील श्री आरडी जानी, वकील श्री अजय ठाकुर, वकील श्री अजय ठाकुर,
आरडी जानी आया ना, तो कहना मुझसे एक बार क्लैरिफिकेशन है, मिल के जाए।
वकील श्री पीवी डोरिया, वकील श्री पीवी डोरिया, वकील श्री पीसी जोशी, वकील श्री पीपी जोशी, वकील श्री एचबी शाह, वकील श्री एचबी शाह, वकील श्री एमजे परीख, वकील श्री एमजे परीख, वकील श्री आर एस चौहान, वकील श्री आर एस चौहान, वकील श्री एसपी परीख, वकील श्री एसपी परीख,
बची गई सीट नंबर 20।
સામે પેલી ક્રોસમાં પેલા બીજી જોશી હાથે થવાનું છે.
हाँ हाँ ये बाकी बाकी અમે 1:03 માં બજી ગયેલું એટલે કામ બતાવું જોઈ લો
સામે બધું અડદ ક્રોસ
પાણી તો હા બંને
દીકરી
હા
સિમ્પ્લિફાઈ કરીએ છીએ અમે.
વકીલ શ્રી એચપી શાહ, વકીલ શ્રી એચપી શાહ, વકીલ શ્રી વાયન શાહ, વકીલ શ્રી વાયન શાહ, વકીલ શ્રી ડીકે પટેલ, વકીલ શ્રી ડીકે પટેલ, વકીલ શ્રી બીડી શાહ, વકીલ શ્રી બીડી શાહ, વકીલ શ્રી બીએચ ભટ્ટ, વકીલ શ્રી બીએચ ભટ્ટ, વકીલ શ્રી આરએન પરમાર, વકીલ શ્રી આરએન પરમાર, વકીલ શ્રી કેએસ શાહ, વકીલ શ્રી કેએસ શાહ, વકીલ શ્રી એસએસ પારેખ, વકીલ શ્રી એસએસ પારેખ, વકીલ શ્રી બીડી શાહ, વકીલ શ્રી બીડી શાહ, વકીલ શ્રી પીએન શર્મા, વકીલ શ્રી પીએન શર્મા, વકીલ શ્રી વાયસી લેવા, વકીલ શ્રી વાયસી લેવા, વકીલ શ્રી આરએચ સોલંકી, વકીલ શ્રી આરએચ સોલંકી, વકીલ શ્રી વીકે ઠાકોર, વકીલ શ્રી વીકે ઠાકોર, વકીલ શ્રી આર્ય પંડ્યા, વકીલ શ્રી આર્ય પંડ્યા.
Yes, sir. There will be two connected matters. One will be CMA contempt and today RCA.
42 एक तारीख
रात रखे
हाँ 1 तारीख का हमारा पर कंटेंट वकील श्री आरटी पारेख, वकील श्री आरटी पारेख, वकील श्री एस ए कहर, वकील श्री एस ए कहर, वकील श्री जेवी वाघेला, वकील श्री जेवी वाघेला,
पब्लिक सर्विस सामावाला नंबर 1 2 5 6 7 8 9 बीजी रवि करो मैं वादा
1 1 2
5 6 7 8 वादा की रवि
कॉपी एमडी टिक करें
नो अभी देखो क्या है सर इसमें सीएमए में
Delete this.
ये आ जाए सर लेते
वकील
ऐसे कहर
हाँ वकील श्री जेवी वाघेला, वकील श्री बीवी पंड्या, वकील श्री बीवी पंड्या, वकील श्री पीवाय मेहता, वकील श्री पीवाय मेहता.
ઇન્ડિયન મેટર આઈન પર દી
सामने कोई आया नहीं
કોપી એક નથી થયું સૌ થઈ ગયું
कितना टाइम हो गया अभी लेते हैं दलील सुन लेते हैं फिर आज अगर नहीं आता
હા શું
वकील श्री सीए पटेल, वकील श्री सीए पटेल, वकील श्री डीएम हिरनपुरिया, वकील श्री डीएम हिरनपुरिया,
બોથ સાઈડ લેખિતમાં આર્ગ્યુમેન્ટ આપી દઈએ મેટર ઓન ઓર્ડર ઉપર હતી બીજી પર
मौखिक कर दो आज करते जाएंगे
મેં રેડી
वकील श्री सीजी भट्ट, वकील श्री सीजी भट्ट.
Sir, we both are ready to proceed with the matter because it was heard at length last time, but unfortunately no order was passed. And the matter was done before earlier. And the matter is of 2024. 2020.
ठीक है लेट्स प्रोसीड टुडे
In second, this is 3 o'clock.
इट्स अप टू यू
Second session. Answer the
Sir, 4 वागे क्या चाहिए? 4 वागे रख दीजिए. subject to the convenience.
I'll be in Mansa Court.
हमें सर हमारे पे को आदमी करवा दीजिए.
He may start. He
हाँ.
may start.
तो after 3 o'clock I may start. थोड़ा आगे रख. Deeply होता है.
छोटा सा.
Isn't it? It's not these.
कहाँ है?
अफजल लाल भाई, शरीफ रसूल भाई.
टाइम से क्यों नहीं आते भाई? हाँ, लेट हो गए इसीलिए तो पूछ रहा हूँ कि टाइम से क्यों नहीं आते. लेट ना आए होगा तो क्यों पूछता. लेट होने का ये मतलब टाइम से ना आने का ये रीजन है कि लेट हो गए. मैं तो यही पूछ रहा हूँ क्यों लेट हो गए. किस दिन वारंट हो जाएंगे तो फिर दिक्कत हो जाएगी. टाइम पर आ जाया करो. बैठो, बाहर बैठो. राहुल सर नहीं आए. पंड्या जी लेंगे. पंड्या जी को बुला लो. हाँ जी.
सीरियल में सीरियल नंबर 10.
लेट द पीपी कम.
चलो रिपोर्ट से एडवोकेट आने वाले 3 बजे. हियरिंग में
3 बजे बेल में.
बीएल में
क्या है?
पूछा.
ठीक है, बट फिर ये एक्सपेक्ट मत करना कि जरूर आज ही ऑर्डर हो जाए.
ना ना.
टाइम मिला तो आज कोशिश करूंगा, अदरवाइज कल. टाइम पे किसने लिखा?
दिखाई दे रहा है। तो मेरे को जाना है अहमदाबाद सर, फैमिली पार्टनर।
कैसे करूँ सर, बताइए आप।
मैंने तो पैसा सब भर दिया है सर, पूरे पूरा।
सर पूरे पूरा तो कंप्रोमाइज का होता है।
हाँ लेकिन वो आए नहीं सामने वाले। मैं उसको भी पूछा है तो कोई दिखाई नहीं दे रहा।
आ
मैं तो
जाएंगे, देख लेते
मैं
हैं।
पहचानता नहीं हूँ, इसीलिए तो वकील भी नहीं आया।
हम्म, देखना ही लास्ट टाइम 4 दिन। Then 5. आपने 3:20 करवाया जमा।
3:20 और 1:20 पहले जमा किया। 6/6/26 को जमा किया है।
छः छः को 3:20 किया ना।
हाँ।
ऑर्डर 4 लाख का है।
1:20 पहले जमा किया।
पहले
आई गया।
आपने सर।
ओरिजिनल कंप्लेंट
हाँ, इसमें इन्होंने पूरी रकम तो जमा कर दी है।
जमा कर दिए।
होनी चाहिए आपको।
हाँ, 20% लास्ट टाइम किया था सर।
हम्म,
लास्ट टाइम 20% डिपॉजिट किया था, पूरी कर दी।
20% नहीं सर।
हाँ, ओके 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 जी।
पहले 80 किया था जी।
80,000 पहले।
हाँ
29
पहले
4 को।
20 किया था।
अभी 6
अच्छा में 20 किया है।
जी जी जी।
अभी कुछ बचता है।
नहीं बचता है, मैं कंप्लेंट बुला लूँ सर।
हाँ, बुला के खत्म कर
हाँ
देना।
जी।
अननेसेसरी फिर क्यों लटकाना केस को जब पूरी पेमेंट
नहीं नहीं
बची है।
नहीं नहीं सर, ये विड्रॉ की परमिशन आपसे ले ले।
दोनों एक प्रोसेस दे दो ना, कर देते
हाँ
हैं
हाँ,
आगे।
और कंप्लेंट को बुला देता हूँ।
उसी के साइन से
ऑफलाइन ऑफलाइन
दोनों पार्टीज के एक प्रोसेस दे दो, आप
जी।
आइडेंटिफाई कर दो।
ऑफलाइन मच ऑफ बोले।
ફરિયાદી સાહેબ પાર્ક છે એટલે 3 વાગે આવશે એવું કહ્યું.
3 વાગે આવશે સાહેબ, કેમ કે ડ્રાઈવરની નોકરી કરે છે એટલે સાહેબને લઈને મહેસાણા ગયા છે.
ठीक है 3 बजे आ जाओ।
જી પ્રોબ્લેમ.
तब तक आप भी वहाँ हो, फैमिली कोर्ट जो कह रहे हो।
મેં જાતે
દીપક ઉર્ફે દીપુ મોહનભાઈ, કેતન ઉર્ફે કિશન જયંતિભાઈ, કેતન ઉર્ફે કિશન,
केतन जयंती है,
केतन उर्फे जयंती,
4 नंबर।
हाँ केतन उर्फे किशन जयंतीभाई, केतन जयंतीभाई ना, केतन उर्फे जयंतीभाई, हाँ नहीं कर, जयंतीभाई, हाँ तो 4 नंबर, केतन उर्फे जयंती, हाँ
केतन उर्फे जयंती अच्छा है, केतन उर्फे जयंती भाई भी जज, ये क्या
हाँ।
मतलब?
ऐसा है,
दोनों केतन जयंती तो
हाँ
दोनों केतन है, दोनों के फादर जयंती हैं। तो वो कह रहा है मैं केतन जयंती हूँ, केतन जयंती भाई नहीं हूँ।
सरने मना
बस केतन जयंती भाई तो है,
हाँ।
बर्फ तो नहीं है।
राहुल कनूज,
બે અને 3 નથી।
ये नहीं सुन,
पंडित जी कहाँ चले गए? वहां से तो निकल गए थे, गए कहाँ? शर्मा जी भी उठ गए, पंडित जी निकल गए वहां से। समय रुक जाते हैं। पंडित जी बेल आप ही लोगे आज तो?
नहीं अभी नहीं, मेरे पास नहीं, पूछ लो दिक्कत।
हाँ जी सर, आप कह रहे थे हमेशा आता है, कभी वारंट नहीं हुए इसके?
जी सर,
आप कह रहे थे हमेशा आता है, वारंट नहीं हुए कभी?
नहीं सर, मैं जब से हाजिर हूँ तो बोल नहीं सर।
अब सर ये चीज ऐड मत करो कि मैं जब से हाजिर हुआ।
मैं सर
पहले आपने क्या कहा था?
मैं सबका फाइल किया तब से मैं एग्रीमेंट देता हूँ उनका, हाजिर नहीं किया तो
सर इसमें इतने अभी तक एक विटनेस भी पूरा नहीं हुआ है।
ठीक सर, मुद्दा के लिए
16
पेन ड्राइव सर, पेन ड्राइव के लिए आया कोई बोला पेन ड्राइव आया
सर, आप ही बोल लो, मैं तो बाद में देख लूंगा।
नहीं सर, सर पेन ड्राइव मुद्दा उनके बाकी है, अभी तक आया नहीं सर, इसलिए हम लोग पेन नहीं है।
मैं कब कह रहा हूँ उस बारे में?
जी सर, जी सर,
मैंने कब कहा कि आपकी गलती से नहीं हुआ? तुम तो लिया करो क्या
जी जी सर, जी सर,
मैंने ये बोला कि एक भी अभी विटनेस नहीं हुआ पूरा,
जी सर,
और इसमें 16 एग्जम्पशन अर्जियां हैं
जी सर।
और एक वारंट भी है।
एक वर्ड सर पहले का सर,
पहले का वो नहीं गिना जाता।
जी सर, जब से मैं तब से नहीं है
उस टाइम आप ये नहीं कह रहे थे सर।
नहीं तो आगे सर रखो सर।
वो तो मैं रखवा लूंगा ना सर, आपको चिंता करने की जरूरत है।
जी सर,
पुलिस
सर,
आएगी अपने आप।
इसमें सर क्या वो विटनेस आए थे ना, तो मुद्दामल के लिए करनी थी आपकी, को विटनेस भी नहीं आया, मुद्दामल के लिए ऐसा है सर।
सबमिट कर दो आ जाए, मेरे से मरते आ जाए। हाँ, सरगा से उसका नहीं है, बंद करें। आता वालों लगा हमारी से समझ चलो कौन आई, कौन अच्छा नहीं ना। राणा साहब चलाई। चला Dia tapi banyak
जी पांडे जी, आप ही चलाएंगे बिल।
इसमें क्या है वो એ સચિવાલય ગયા છે કંઈક ઇન્ટરવ્યુ માટે મેં કીધું ના તો જામીનદાર મોકલી દઉં છું એવું કીધું હવે શું કહે છે ફોન કર્યો ત્યાં સુધી એક સાક્ષી લઈ લઈએ સર કિંજલબેન હા
तो उसके पहले लोगों को अर्जा नहीं है, तो 11 बजे नहीं हो तो 7 है 6 7 रखो, अर्जा नहीं है। अज्ञान आ जाओ गए।
એ સાહેબ આ 36-26 માં અમને લેખિત દલીલ આપીને એમાં જરા જોવું પડશે
सर कॉपी रिसीट मैंने कॉपी
મને આપી મેં જોઈ લઉં છું
रिटर्न रिटर्न आर्ग्यूमेंट
अपील में।
હા સર
जी सर
3 વર્ષની છે ને સર
मौखिक
सर मैं मौखिक रिटर्न बंद करवाना छू, पर रिटर्न में कॉपी हमने एडवांस आप दी थी
मौखिक भी कर दो ना।
मौखिक अभी कर दूं।
મને જુબાનીઓ આપતા મારે ઝેરોક્સ કરાવી હા કારણ કે સાહેબ જુબાની ઉપર એમણે એકલી અરજી જ મૂકી છે એટલે જજમેન્ટ અને જુબાની જે સાહેદો કયા કયા સાહેદે શું કીધું છે અને જે એના હિસાબે જોવું પડે હોય તો
कराई दीजिए, सेट कराई दीजिए।
એક ડેટ સાહેબ
14
14/9
હા યસ
कॉम्प्लेक्स।
14 है 108 पेज डी लिस्ट के लिए।
इसमें पंडित जी डी लिस्ट अभी तक बाकी है।
हाँ सर
108 23 डी लिस्ट मुद्दामाल अभी तक नहीं।
ट्रांसफर होके सर मैटर आई है
हाँ कई कोर्ट में
ट्रांसफर
उससे क्या फर्क पड़ता है सर?
ठीक है
डी लिस्ट फाइल करने में ट्रांसफर का क्या फर्क पड़ेगा?
वहाँ से पीपी अलग थे
अरे कोई मतलब नहीं
सर पुलिस ने देनी है ना, वो होते हैं।
पुलिस
पीपी साहब खुद थोड़ी बनाएंगे
नहीं,
डी
नहीं,
लिस्ट, पुलिस देगी तभी तो।
नंबर का
108 23 અને 54 23 માં લિસ્ટ આપી જ દઉં છું અને પેલો રિપોર્ટ બાકી
और साहब एक साथ सिलेबस 7 के साथ बेल एप्लीकेशन 11/5
देखते हैं अभी वो राव साहब आ रहे हैं या यही लेंगे।
साहब उसमें कल का डेट कल का डेट चाहिए होता है क्योंकि एडवोकेट कल ही कल आने वापस।
ठीक है जी साहब।
सीरियल नंबर 7 को
मैं
7
सीरियल नंबर 12 में पेटिशनर से मुद्दामाल रिवीजन एप्लीकेशन प्रोहिबिशन में
नंबर 2
तो नेक्स्ट हाथों नोटिस ले जाओ आरपीडी
यस
सीरियल नंबर 8 CRM एग्जामिनर जी।
पीपी साहब आ जाने लेते हैं।
ओके वेरी मच।
सीरियल नंबर 18
है नहीं एसटी के लिए सर्विस हो गई मेल होती है पूरी, उनकी भी मेल होती है।
इन्फॉर्म कर दीजिए।
देख लो आ रहे हैं तो ठीक है, नहीं तो फिर आगे चले। 60 डेट तो हो गई रिट्रीसमेंट के लिए।
सीरियल नंबर 21 नंबर 1 ओटीपी स्पीड पोस्ट की एप्लीकेशन
वो ना सर कब से पड़ा हुआ है।
करवा देता हूँ स्पीड से। सीरियल नंबर 22
एम्प्लॉय बाकी है,
उसमें भी कोई आया नंबर 1
कोई नहीं आया अब तक।
कंपनी रहती है कोई रहती है 23
एक करके फिलहाल ये
ये पर आ जाते हैं नंबर दे करके कोई कंपनी। सीरियल नंबर 26
26 27 बनने एक साथ से चेक
26 27 दोनों कनेक्टेड है।
रिप्लाई बाकी है इसमें।
रिप्लाई में नंबर
28 उसमें भी सर वो स्पीड पोस्ट की एप्लीकेशन डाल देता हूँ क्योंकि 21 के साथ
28
इसमें तो सर्विस हो चुकी है।
एनीथिंग हाँ तो उसकी कनेक्ट सर 21 वाला ही जो नहीं आया वो देख लिया सीरियल नंबर 29
रिप्लाई માટે છે
એમાં સર નંબર 2 સર पे सर वीटी फाइल करो।
बस सर
सर एक है सीरियल नंबर देख के बताएं एक MSCP 16/26 24 नंबर ऑपरेंट नंबर 2 की तरफ से आप वकालतनामा फाइल करो और रिप्लाई
जी पांड्या जी, बाकी बहुत सारे पड़े हैं आपके तो अभी।
जी सर
अभी आपके बहुत सारे केस हैं,
हाँ जी
बहुत से केस हैं अभी आपके, क्या करना है?
जी લખાઈ મોકલી દીધું સાહેબ તાત્કાલિક ચાલુ કરવાનું કામગીરી ક્લાર્કને બોલાવી
मुद्दामाल
મુદ્દામાલ વાળું એ લિસ્ટ છે અને FSL રિપોર્ટ નથી આવ્યો એ લખીને આપી દીધું તાત્કાલિક ફોન કરે 4 કેસમાં એમ
कौन कौन से? 94 માં લખી,
ગઈ નીચે
94 23 માં
એ 4 લખીને આપી દીધા સાહેબ
आईओ टू अपीयर इन पर्सन। 3 साल से ऊपर हो गए, क्यों नहीं आती इसमें? आईओ तो होगा नहीं, क्योंकि यही कर लो।
94
હા એટલે બે પુરવણી ચાર્જશીટ છે કેવું છે જોઈ લેવું પડશે એટલા માટે મોકલ્યો મેં જોવા માટે હા એ લખીને આપી લિસ્ટ બનાવવા માટે
आईओ टू अपीयर इन पर्सन 54 25 એમાં પણ
ખાલી
54 25
લિસ્ટ વાળું છે ને એવી
પ્લેસ
હા
મુદ્દામાલ
એ
बनना।
નીચે મોકલી દીધું સાહેબ એટલે 4 લખીને મોકલી દીધું
20 26 માં भी डी लिस्ट है।
એમાં મુદ્દામાં મેઇન કેસ આ એક પુરાણું તકલીફ
અને પેલું ચાંદખેડા વાળું આવ્યું નથી મુદ્દા માલે
અને ચાંદખેડા
હા જી
મુદ્દામાં એમાં FSL રિપોર્ટ
FSL રિપોર્ટ બાકી છે એ બી મંગાવ્યો ફોન કરો
એવિડન્સ માટે
और ऑफिस में बैठे होने पे तो डेट है।
હા
13 नंबर में 1 અને 4 છે, 2 અને 3 ને વરણ
હા
2 અને 3 ના વરણ
આ બે ને ત્રણ પુરાણ
108 23 માં अफजल અને शरीफ गुलाम। जामीन जी आएंगे राव साहब?
સચિવાલય મેં ફોન કર્યો એટલે કે હજુ થોડી વાર લાગશે એટલે 3 વાગે રાખી હશે જામીન
नो नो
એફિડેવિટ ના પેપર આપી દીધા 21 છે ને તારે 21 થોડી હા 21 એફિડેવિટ આપી હા 21
हाँ
જે 54 માં દિવ્યરાજસિંહ
3 વાગે
દિવ્યરાજસિંહ
14 9
ગુજરાત પોલીસ પીએમ
20 में नहीं आया ना।
વકીલ BS પરમાર વકીલ CBS પરમાર
एप्लीकेशन तो नहीं है full। अच्छा ठीक है हाँ जी सर, बाकी किसमें है?
11 नंबर
जामीन जी तो राव साहब आ जाए।
3 વાગે રાખો 3 વાગે તમે આવી જાઓ
हाँ जी, आप लोग किसमें है बाकी?
36 in civil. Yes, sir. Okay. Please. Present appeal is filed against the dismissal of the suit, being the regular civil suit number 19 of 2006. The original suit was filed for the relief of declaration that sale deed dated 10/6/1996 is null and void, illegal, without consideration, void ab initio, and nullity, and as the same has been executed by concocting a fraudulent power of attorney by defendant number 1 and 2 in coalition. What is the case pleaded in the plaint, Your Honor? So far as the case pleaded in the plaint is concerned, Your Honor, if you are to peruse the plaint, it is the case of the plaintiff that plaintiff is the owner of the suit property, Your Honor, in para 2. May I with Your Honor? May I read? Yes. આ કામના વાદીએ સદર દાવાળી મિલકતના તમામ પ્રકારના શેરફાળા તથા રાઇટ્સની ખરીદી કરવા અમો વાદીએ સદર રાજધાની સોસાયટીના ઓર્ગેનાઇઝર ને જમીન ફાળો બાંધકામ તેમજ તમામ પ્રકારની રકમો ચૂકવી આપેલ છે. આમ સદર દાવા આવેલી મિલકતનો તમામ પ્રકારનો અમે વાદીએ ચૂકવી આપેલ અને ત્યારબાદ રાજધાની કોઓપરેટિવ સોસાયટી દ્વારા અમો વાદીને શેર પણ ફાળવી આપવામાં આવેલ છે, જેનો શેર સર્ટિફિકેટ નંબર 356 થી 360 સુધીના અમો વાદીના નામે ફાળવવામાં આવેલા છે. આમ તે રીતે અને તે પ્રકારે સદરુ દાવાવાળી મિલકતના ખરા અને કુલ સ્વતંત્ર માલિક કબજેદાર અમો વાદ્યો છે.
एक मिनट रुकिए सर, एक मिनट रुक जाइए,
પ્લીઝ નાવ સર.
एक मिनट रुक जाइए सर.
આમ સર.
ये किसकी परमिशन से लगाई है? आपने किसी कोर्ट से कहीं से कोई परमिशन ली है? क्यों लगाई है? क्या ये करने से कुछ नहीं होगा? जवाब दो, पहले क्यों लगाई? किसने आपको अथॉरिटी दी एक आरोपी को हथकड़ी पहनाने के लिए? तो जहां तक मुझे पता है सुप्रीम कोर्ट तक तो मना किया हुआ है, उससे ऊपर हो गए आप. मैं कुछ पूछ रहा हूं, मुझे जवाब चाहिए. आगे आ जाओ. किसने आपको कहा ये लगाने के लिए? क्यों लगाई? ठीक है, जमा कर लो यहीं, पैसे लेके जाए. कौन सा इनका नया कानून बना के हथकड़ी लगा के ले जाएंगे यहाँ से? हाँ तो ये रख दो ना यहीं, इसकी जरूरत क्या है आपको? हाँ अच्छा, तो सेफ्टी के लिए आप अपनी मर्जी से कुछ भी स्टेप्स ले सकते हैं. लॉ से ऊपर आप हो गए, कानून जो कहता है वो तो नहीं करोगे, जो कानून मना करता है वो आप स्टेप्स लोगे सेफ्टी के लिए. आपके हिसाब से होगा सब कुछ? जिस दिन एक भी कंप्लेंट आ गई ना, आप कंटेम्प्ट में हो, नौकरी भूल जाना. हाँ जी सर.
Please. Thereafter, sir, plaintiff has executed a bana
जाओ. Yes.
in favor of defendant number 1, Your Honor, J.K. Shah, Jitendra Kanayalal Shah. And the same was executed on 2nd February 1996, Your Honor,
Executed
by plaintiff in favor of defendant number 1. Agreement to sale. And the suit valuation is valued at 375 per square yard. And for that purpose, earnest money of rupees 1 lakh was paid by defendant number 1 to plaintiff. And so far as the tenure of agreement to sale is concerned, it is fixed for 1 month. Thereafter, defendant number 1 was not able to make payment with regard to remaining sale consideration within the period of 1 month, which was fixed in the Banakhat. Therefore, Banakhat was cancelled by amicably, Your Honor. And plaintiff has returned the earnest money of rupees 1 lakh to defendant number 1, Your Honor. And for that purpose, a cancellation was made on 14th June 1996, Your Honor. So it is the case pleaded in the plaint that plaintiff has not executed any power of attorney in favor of defendant number 1, Your Honor. The Banakhat which was executed in favor of defendant number 1 was cancelled, Your Honor, due to non-availability of the fund with defendant number 1. Thereafter, sir, in the year 2005, when plaintiff wants to sell this property, has published a public notice in newspaper Sandesh Daily, Your Honor, on 8/10/2005. In response to that public notice, Your Honor, defendant number 1 filed an objection to that effect that defendant number 1 has executed sale deed as a power of attorney holder of plaintiff in his favor on 29th March 1996.
Twenty?
1996. 20th March, 29th March, 29 March 1996.
In his own favor.
In favor of defendant number 2. So, plaintiff has filed the suit in the year 2006, Your Honor. Originally, the suit was for the cancellation of sale deed executed by defendant number 1 through a fraudulent power of attorney in favor of defendant number 2. So, earlier suit, so far as originally, suit number being RCS 19 of 2006, Your Honor, was filed for declaration and cancellation of sale deed, Your Honor. And it was specifically raised contention in the plaint, para 5, Your Honor, with regard to power of attorney on page 5. May I read? આમ વાદીના આઘાત અને આશ્ચર્ય વચ્ચે વાદીના દાવાવાળી મિલકત પર પરત્વેના કાયદેસરના હકો જીવંત અને જારી હોવા છતાં આ કામના પ્રતિવાદી નંબર 1 અને 2 ના એકબીજાના મેળાપીપણામાં અમો વાદીના નામનો ખોટો બનાવટી પાવર ઓફ એટર્ની બનાવી તેનો ખોટી રીતે ઉપયોગ કરી તારીખ 29/3/96 ના રોજ અમો વાદીના નામના ખોટી રીતે સ્ટેમ્પ પેપર ખરીદી તેના ઉપર 29/3/96 ના રોજ લખાણ ઉભા કરી તારીખ 10/6/96 ના રોજ અનુક્રમ નંબર 2099 થી નોંધણી કરવામાં આવેલ છે. સદર વેચાણ દસ્તાવેજ આ પ્રતિવાદીઓ દ્વારા અમો વાદીના કાયદેસરના માલિકી હકોને નુકસાન કરવાના બદઅસરથી કરવામાં આવેલ છે. અમો વાદીના કાયદેસર માલિકી હકોના અનુસંધાને આ દાવાના પ્રતિવાદીઓને દાવાવાળી જમીને પરત્વે કોઈ હક પ્રાપ્ત થયેલ ન હતો ને નથી. સદર વેચાણ દસ્તાવેજ અમો વાદીના નામનો ખોટો બનાવેટી પાવર ઓફ એટર્ની ઉભો કરી અમો વાદીની સહી સંમતિ મેળવ્યા વિના સદર વેચાણ દસ્તાવેજ કરવામાં આવેલ હોય. આ વેચાણ દસ્તાવેજ મૂળથી જ ખોટો બનાવટી ગેરકાયદેસરનો બિનઅમલી બિનઅવેજી વોઇડ એબ ઇનિશિયો નલિટી સ્વરૂપનો છે. સદર વેચાણ દસ્તાવેજના આધારે આ કામના પ્રતિવાદી નંબર 2 નાને કોઈ પણ જાતનો હક અધિકાર કે લાભ ભાગ ઉપસ્થિત થયેલ નથી. સદર ખોટું ગેરકાયદેસર રીતે ઊભું કરેલ કહેવાતું પાવર ઓફ એટર્ની પણ રજીસ્ટ્રેશન એક્ટની કલમ 32 તથા 33 ની જોગવાઈ મુજબ રજીસ્ટર કરવામાં આવેલ નથી અને તેથી તેના આધારે કરવામાં આવેલ વેચાણ દસ્તાવેજ કાયદાકીય પ્રબંધ વિરુદ્ધનો છે તથા સદર દસ્તાવેજ બિન અવેજી બિન અમલી નલિટી સ્વરૂપનો છે. સદર વેચાણ દસ્તાવેજમાં જણાવ્યા મુજબ દાવાવાળી મિલકતનો કબજો કોઈ રીતે કે પ્રકારે તબદીલ થયેલ નથી કે સદર વેચાણ દસ્તાવેજ માત્રમાં વાદીના કાયદેસરના હકોને નુકસાન પહોંચાડી ખોટો હકો ઉભો કરવાના આશયથી કરવામાં આવેલો છે. So it is a specifically averred in the plain that power of attorney is a fraudulent power. And in view of these averments, the prayer prayed in para 8 on page 7, Your Honor. Para 8A is in respect of sale deed and para 8B is in respect of power of attorney, Your Honor. Now, sir, during the pendency of the suit, Your Honor, an application via Exhibit 46 was filed by defendant number 4 to join him as a party defendant, Your Honor. As during the pendency of the suit, the property was transferred in favor of defendant number 4 in the year 2008, Your Honor. The said application was allowed, Your Honor. And defendant number 4 has entered his appearance and filed his reply via Exhibit 76, Your Honor. So far as defendant number 1 and 2 is concerned, they have not filed any reply. And their right to file reply was closed by the Honorable Court.
What about 3?
1 and 2, Your Honor.
What about 3?
So 3, so far as 3 is concerned, Your Honor, during the pendency of the suit, plaintiff has executed banakhat in favor of defendant number 3. So defendant number 3 has moved an application to join him as a party defendant. So there is no prayer against defendant number 3, Your Honor.
So no reply was filed.
No reply. So far as 76 is concerned, reply filed by the defendant number 4. It is the case of the defendant number 4 that he can be said to be a bona fide purchaser. I will later on invite your Honor's attention to the reply and averments made in the reply. So far as the documentary evidence is concerned, Your Honor, plaintiff has produced documents, original document via list exhibit 71, Your Honor. So those are the relevant. I will invite your Honor's attention to that document. So far as oral evidence is concerned on plaintiff side, an affidavit in lieu of chief examination was filed at exhibit 74. The defendant, neither defendant number 1 and 2 nor defendant number 4 produce any documentary evidence or oral evidence, Your Honor, to prove their case. Now, sir, first and foremost, sir, I would like to invite your Honor's attention to the original banakhat, on the basis of which defendant number claiming that plaintiff has executed power of attorney also, and on the basis of that power of attorney, he has executed registered sale deed in favor of defendant number 2. Now let us look at the banakhat. The banakhat is produced at exhibit 101, Nisani 72/13, Your Honor. The RNP is there. પેજ નંબર 127 કેવું વંચાયું. So far as sir ownership is concerned, ownership is not disputed by the defendant. કારણ કે એમનો જ કેસ એવો છે કે અમે એના પાવર ઓફ એટર્ની ના આધારે એટલે એ માટે સાહેબ I would not indulge your honor to refer those documents about the ownership. Let us look at the exhibit 101. એમાં sir બાનાકર, it is લખાવી લેનાર, that is Jitendra Ramalal Shah, that is defendant number 1, originally defendant number 1, here in opponent or respondent number 1. Lucky Apnar is Ramchandra Bhai Arjun Bane, that is the original plaintiff. So far as on page 2, first para is in respect of first and second para. Sir, properties description is there.
This Banakat is disputed.
No, sir. But I am only inviting your honor that by this Banakat, possession was not handed over you. That's why I am referring this Banakat.
Where is the cancellation?
Cancellation is next one. Cancellation is at produced. At 102. Exhibit 102.
This handwritten.
Handed. Yes, it is handed. બાનાખતમાં જણાવેલ સમયમાં પાકો દસ્તાવેજ, it is 14th June 1996. સમયમાં પાકો દસ્તાવેજ ના કરી શકવાથી અમો આ સોદો કેન્સલ કરીએ છીએ. તમો અમોને બાનાખતમાં જણાવેલ અવેજની રકમ રૂપિયા 1 લાખ પૂરા વગર વ્યાજે પરત કરશો. વ્યાજ લેવા અમો હકદાર નથી. રૂપિયા 1 લાખ અંકે રૂપિયા પૂર્ણને આજરોજ તારીખ 14/6/96 ના રોજ તમારા તરફથી મળી ગયેલ છે. હવે પછી આ સોદો કેન્સલ થયેલ ગણાશે. હવે કોઈ પણ જાતની તકરાર રહેશે નહીં. આ જમીન તમો બીજાને તબદીલ કરી શકો છો. And it is signed by J.R. Shah. Same signature in બાનાખતીઓ. And one only said page 7 of Banakar, so far as possession is concerned. And page 6. The page 6 માં first paragraph. આ બાનાખતની મુદત 1 માસની નક્કી કરવામાં આવેલ છે. આ મુદત દરમિયાન બાકીની ચૂકતી અવેજની રકમ લખી આપનારને લખાવી લેનાર ના આપે તો આ બાનાખત રદ બાતલ ગણવાનું છે. And page 7 first paragraph. સદર મિલકતનો પાકો વેચાણ દસ્તાવેજ અમારે તમારા નામનો અગર તેના નામનો તમારી અનુકૂળતા મુજબ વેચાણ આવેદની બાકીની રકમ લઈને કરી આપવાનો છે ને સદરુ મિલકતનો માલિકી હકે કબજો અમારે તમને સોંપી દેવાનો રહેશે. So possession was not handed over at the time of the execution of Banakat. And that Banakat was cancelled. Now sir, let us look at the sale deed, the disputed original sale deed of 1996. It is produced at 107.
Xerox copy. It is Xerox.
So it is already produced at the time of execution. So at present, I cannot do anything. And it was not disputed by the other party. And it is an admitted document here. Yeah, document thayelo.
I'm not disputing it.
Sorry.
This is 107, which is Xerox.
Please, please. So this document લખાવી લેનાર, that is Rakesh Kanayalal Jani, that is defendant number 2. લખી આપનાર રામચંદ્ર અર્જુન બાને ના Kul Mukhatyar Jitendra Ramanlal Shah. So this document was allegedly executed by defendant number 1 on a fraudulent power of attorney of plaintiff, Your Honor. Now, sir, page number 4 of document, Your Honor. Page number 4. સાહેબ ઉપર જે સિક્કો છે ને એમાં 4 નંબરનું દેખાશે 2099 4 10 મળ્યું સર you have got the registered stamp, Your Honor. કારણ કે આમાં there is no page number. So it is 4. એમાં there is a description of property. In that the consideration was narrated from last 4 line. સદર મિલકત અમોએ તમોને કુલ અંબરામ ન દાવે અઘાટ વેચાણ 69 પૂરામાં તમો લખાવી લેનાર પાસેથી નીચે મુજબની વિગતે લઈ તમોને વેચાણ આપી તમારા ખાલી અને પ્રત્યક્ષ કબજે માલિકી હકે સોંપેલ છે. મળ્યું? So consideration was only 69,100. Again, sir, earnest money was rupees 1 lakh in Banakar. So it is a lesser amount than the amount mentioned in Banakar. Secondly, Your Honor, by this document, possession was handed over. How and in what manner defendant number 1 came into possession, the sale deed is totally silent. Secondly, sir, sale deed is totally silent about the Banakar. Sale deed is totally silent about the power of attorney. Posing for a moment over here, Your Honor. So, and furthermore, the power of attorney, copy of the power of attorney was not also produced with the sale deed, Your Honor. Because it was in the year 1996, it was not mandatory to produce the power of attorney. Nowadays, it is required. But in the year 1996, it was not mandatory. But posing for a moment over here. If we believe that the Banakat and power of attorney can be said to be a couple with interest. In that case, Your Honor, the defendant number 1 has right to execute the sale deed. But that purpose, the evidence is required to be laid. And if power of attorney is with consideration, then the same is required to be registered in view of the latest judgment of the Honorable Gujarat High Court. Those judgment is in 2 aspects. કે power of attorney આપનાર અવસાન પામે તો power of attorney couple with interest હોય તો પણ power of attorney ની દસ્તાવેજ ના થઈ શકે. પણ Honorable High Court was also held that once one who coming before the court and claiming that power of attorney is coupled with interest, then that power of attorney is required to be registered. Here in the instant case, no power of attorney is found on the record here. And it is obvious on the part of defendant number 4. સાહેબ, આ original જે 1996 નો document છે, 2008 માં defendant number 4 purchase કરી, તો 96 ના તમામ documents એની પાસે આવે. Neither defendant number 1 or 2, nor defendant number 4 had produced the original power here to establish that the plaintiff has executed a power in favor of defendant number 1. So it is the crux of the matter. And Honorable Trial Court, when at the time of, I will invite your honors to the observation made by the trial court. Trial court heavily relied to that effect that plaintiff is miserably failed to produce the power of attorney. How? So plaintiff can produce the same. Because, so it is not the case કે મેં power કરી આપેલો છે પણ ખોટો છે, આ છે, તે છે. So it is the case of the plaintiff that I have not executed any power in favor of defendant number 1, and the alleged power of attorney is concocted and fraudulent and got up by defendant number 1 in collision with defendant number 2.
Where is your affidavit in evidence and cross-examination?
So far as the affidavit is concerned, it is at 74, Your Honor. Plaintiff affidavit. $74. હા ટાઈપ કોપી છે વાદી નંબર 1 સાહેબની સર તપાસ એવું લખ્યું છે.
એ શું છે 72
RNP માં જ હશે.
હા
So in affidavit, in para 5,
Affidavit, you have reiterated your claim.
repeated the plaint, and in para 5, I have averred about the cancellation, Your Honor.
Coming to cross-examination.
So far as cross is concerned, Your Honor, cross is very narrow cross. વાંચું સર હું હાલમાં ગુજરાત અને it is only cross examination was done by only defendant number 4. 1 and 2 has not cross examined. હું હાલમાં ગુજરાત ગાર્ડન સિટી બેલવેટર કોમ્પ્લેક્સ જગતપુર રોડ અમદાવાદ ખાતે રહું છું. તમે કેટલા સમયથી સરનામે વરસાદ કરો છો? સદર સરનામે છેલ્લા 1 મહિનાથી રહું છું. અમારું મકાન બની રહ્યું છે એટલે હાલ ભાડે રહીએ છીએ. દાવા અરજીમાં જણાવેલ સરનામાવાળા મકાન બનાવતા નથી પરંતુ બીજું મકાન બનાવીએ છીએ. અમારું જે નવું મકાન બને છે તે જગતપુર રોડ પર આવેલ છે. મારી રાજધાની કોઓપરેટિવ હાઉસિંગ સોસાયટી લિમિટેડના દાવાવાળી મિલકતના પ્લોટ નંબર 82માં મારો પોતાનો છે જેના ઉપર બાંધકામ થયેલ નથી. અમારી પાસે પૈસાની સગવડ ન હતી તેમજ સદર જમીન એનઓસી થયેલ ના હોય પ્લોટ નંબર 82 ઉપર બાંધકામ કરી શકેલ નહીં. એનઓસી એટલે જરૂરી ઓથોરિટી પરવાનગી ન હતી. આ પરવાનગીઓ સદર મિલકત સોસાયટીએ લાવવાની હતી જે બાબતની સોસાયટીમાં મેં કોઈ રજૂઆત કરેલી નહીં. એ વાત ખરી છે કે મેં દાવાવાળી મિલકત અજીતમલ જવાનમલ શાહને વેચાણ આપવા તૈયાર બતાવેલી જે ઘણા વર્ષો પહેલા બતાવેલી. મેં સને દાવાવાળી મિલકત અજીતભાઈ જવાનમલ શાહને સને 2005માં તૈયારી બતાવેલી. ધેટ ઇઝ ધ ડિફેન્ડ નંબર 3. પ્રતિવાદી નંબર 3 સાથે કરેલ બાનાગત રજૂ કરવા ખુશી નથી કારણ કે સદર બાનાગત પ્રતિવાદી નંબર 3 પાસે છે. સદર બાનાગત કેટલા રૂપિયાનું થયેલ તે કહી શકું નહીં. તે વાત ખરી નથી કે મેં પ્રતિવાદી નંબર 1 નાને કોઈ દાવાવાળી મિલકતનો પાવર ઓફ એટર્ની કરી આપે. તો ક્વેશ્ચન વોઝ આસ્ક્ડ. મેં દાવાવાળી મિલકત રાજધાની સોસાયટી પાસેથી 80-81માં ખરીદ કરેલી. મેં દાવાવાળી મિલકતના નાણાં સુવિધા એન્જિનિયર્સને ચૂકવેલા. મેં કેટલા રૂપિયા ચૂકવેલ તે હાલ યાદ નથી પરંતુ મેં તેની પહોંચો રજૂ કરેલ છે. હું પ્રતિવાદી નંબર 1 નાને ઓળખું છું. પ્રતિવાદી નંબર 1 નાને દાવાવાળી મિલકતના વેચાણ દલાલ તરીકે ઓળખું છું. તે વખતે મારી ઓળખાણ પ્રતિવાદી નંબર 1 સાથે દલાલ તરીકે થઈ ત્યારે પ્રતિવાદી નંબર 3 નાઓ હાજર ન હતા. તમે પાવર ઓફ એટર્ની પ્રતિવાદી નંબર 1 ને આપેલ ન હોવા છતાં પ્રતિવાદી નંબર 2 નાની તરફેણમાં વેચાણ દસ્તાવેજ પ્રતિવાદી નંબર 1 નાએ કરી આપેલ છે તે વાત ખરી છે. આ પાવર ઓફ એટર્ની ક્યારે થયેલો તેની જાણ નથી. મને 72/20 નો વેચાણ દસ્તાવેજ બતાવવામાં આવે છે, તે જોઈને કહું છું કે મેં આવો કોઈ દસ્તાવેજ રાકેશ કનૈયાલાલ જાનીને કરી આપેલ નથી. સદર દસ્તાવેજ જોઈને કહું છું કે જે તારીખ 29/6 ના રોજ થયેલ છે, જે સદર દાવો 2006 માં કરેલ છે. 2006 પહેલા એટલા માટે દાવો કરેલ નથી કે અમારે કંઈ કરવાનું આવતું ન હતું, પરંતુ અમારો દીકરો મેજર થતા સને 2006 માં દાવો કરેલ, તે પહેલા હું કંઈ કરી શકું તે સ્થિતિમાં ન હતો. મારા દીકરા પાસે પૈસા હતા, મેં સદર બાબતની તપાસ કરતા બનાવની જાણ થઈ. એ વાત ખરી નથી કે પ્રતિવાદી નંબર 3 ના સને 2005 એવું કહેલ કે મારે પૈસા જમીન ક્લિયર કરી મને વેચાણ આપી દો. મને નિશાની 72/28 બતાવવામાં આવે છે, તે જોઈને કહું છું કે સદર અરજીમાં મારી સહી છે અને શકુંતલાબેનને વેચાણ આપવા માટે અરજી કરેલ છે, તે દાખલાંક 93 આપવામાં આવે છે. અમારે માત્ર પ્રતિવાદી નંબર 3 સાથે વેચાણની તત્પરતા હતી, તે સિવાય કોઈ સાથે વેચાણ કરવાની તત્પરતા ન હતી. તે વાત ખરી છે કે અમે સદરુ વિકલ્પ વેચાણ કરવા માંગતા હતા. તે વાત ખરી છે કે પાવર ઓફ એટર્ની ખોટો થયેલ છે, તે બાબત મેં કોઈ પોલીસ ફરિયાદ કરેલ નથી. તે વાત ખરી છે કે સદર પાવર ઓફ એટર્ની ખોટો થયેલ છે, તે અંગે કોઈ સક્ષમ અધિકારીને કોઈ ફરિયાદ કરેલ નથી. તે વાતનો મને ખબર નથી કે સોસાયટીમાં આંતરિક ઝઘડાઓ ચાલે છે. તે વાતની મને ખબર નથી કે રાજધાની સોસાયટી ખાતે કોઈના પૈસા જમા થયેલ નથી. સદર પૈસા સુવિધા એન્જિનિયર વાળા લઈ ગયેલા છે. સદર દાવાળી જમીનનો 7/12 ઉતારો અમારી પાસે છે. હું સદર 7/12 રજૂ કરવા ખુશી છું. સદર 7/12 કોના કોના નામ છે તેની મને ખબર નથી. હાલમાં ચેરમેન સેક્રેટરી કોણ છે તેની મને ખબર નથી. તે વાત ખરી નથી કે અમો 96 પછી રાજધાન સોસાયટીમાં ગયેલ નથી. તે વાતની મને ખબર નથી કે રાજધાની સોસાયટીમાં બિનખેતીનો હુકમ મળ્યો તે હાલ અમલમાં છે કે કેમ. તે વાત ખરી નથી કે સોસાયટીના ધારાધોરણ હતા નહીં, તેમજ જમીન ઉપર કોઈ ડેવલપમેન્ટ થયેલ ના હોય. મેં કેવાટા પ્લોટનો કોઈ પાવર ઓફ એટર્ની કરી આપેલ, તે વાત ખરી નથી કે મેં પાવર ઓફ એટર્ની કરી આપી સારામાં સારી રકમ મેળવેલ છે. તે વાત ખરી છે કે સદર દાવામાં પ્રતિવાદી નંબર 4 તરીકે મહેશભાઈને દાખલ કરવા અરજી કરેલી. તે વાત ખરી છે કે સદર દાવાના કામે દાવા અરજીમાં સુધારો કરવા કોઈ અરજી કરેલી નથી. તે વાત ખરી નથી કે દાવાવાળી મિલકત પ્રતિવાદી નંબર 3 ને મળી જાય તે માટે હાલનો દાવો કરેલ છે. તે વાત ખરી નથી કે પ્રતિવાદી નંબર 3 ને કરી આપેલ દસ્તાવેજ રદ કરવા કોઈ માંગણી કરેલ નથી. તે વાત ખરી નથી કે મિલકતનો ભાવ વધવા માટે અમે ખોટો દાવો. So nothing is coming out from the cross examination that defendant plaintiff has executed a power of attorney in favor of defendant number 1. On the contrary, he is denied. Now, sir, it is my humble submission to that effect that the burden lies upon the defendant, because it is a clearly averred in the plaint and also by cogent evidence. Plaintiff has proved this thing that he has not executed a power of attorney. Possession was not given to the defendant number 1, Your Honor. So first of all, defendant number 1, 2 has to discharge the burden that no, power of attorney is very much and validly executed by plaintiff in favor of defendant number 1, and on that authority, defendant number 1 has executed a valid sale deed in favor of defendant. So far as original power of attorney, if posing for a moment power of attorney was there, the original was very much lies with the defendant number 1 and 2 or with defendant number 4. So it is the bounden duty of the defendant number 4 to produce the same on record here. If it is there,
Kindly
I'm
go
sorry.
through the issues.
Please.
The burden was on plaintiff.
100% burden was on plaintiff, but that burden was wrongly.
Have you challenged this order or moved an
100%
application?
it was not challenged.
Had you moved any application
No, sir,
for that?
there is
Then
no.
You have accepted it.
100%.
Then you had burden was on the plaintiff.
No issue was there, Your Honor. But the law, what is the law? As per section,
Law 101 says you have come to the court.
100%.
So burden is on.
Sir, so far as 101 is concerned, Your Honor, if we peruse the 101, Your Honor, as per section 101, the burden lies upon a person who asserts the fact before the honorable court. Here in the instant case, I have asserted that I have not executed the power of attorney. But honorable court has to see the circumstances here. I have specifically pleaded, sir, it is of the year 1996, the sale deed of the year 1996. So it was not, at that point of time, it was compulsory on the part of.
That was before cancellation. Before cancellation
100%.
of Banakat.
100%. Sir, but the Banakat was cancelled. and it was cancelled
Agree, you say
by
there was
defendant
no
number
power attorney, it was only Banakat.
100%. It is a Banagat. Sir, Banagat is a, what is the right avail? One can avail a right. Defendant number one can file a suit for passive performance, Your Honor. And Your Honor has to look at the consideration here. So Banagat is in respect of more amount than the sale consideration, which was mentioned in sale deed, Your Honor. On the contrary, defendant number one has made payment of rupees 1 lakh by way of earnest money, and the sale deed was of the year of the same year is only for 69,000. So my humble submission is to that effect that defendant number one, though the power of attorney, alleged power of attorney is in his custody, failed to produce the same year.
What is the ground given by the court?
So please, Your Honor, if Your Honor peruse the judgment, Your Honor, on page 12, issue number 1, reasons.
Page number?
12 of the judgment.
Yes.
May I with you? In last 4-5 lines. It is noteworthy that the said power of attorney has not been brought on record. Further, from the copy of the sale deed produced by Exhibit 107, it appears that the said sale deed is registered sale deed, and it is specifically mentioned in the sale deed that Ramchandra Arjunbhai Bane had given power of attorney to Jitendra Ramanlal Shah, that is the present defendant number 1, and its registered sale deed, which implies that the copy of the said power of attorney would have been availed from the register office. So it is the presumption on the part of the Honorable Trial Court. Okay, it was produced with the registered power of attorney, but the same was not there. If Your Honor mark the pages of the sale deed, the pages does not reflect that the power of attorney is also produced. Your Honor.
But it was registered.
So far as sale deed is concerned, it is registered one. Power of attorney is not
Power of
registered. No,
Power
sir.
attorney, no.
May I read further? Once again. They had given power of attorney to J.R. Shah, present defendant number 1, and it is registered sale deed, not a registered power of attorney, which implies that the copy of the said power of attorney could have been availed from the register office of the plaintiff and produced the same on record. Also, there is nothing on record to show that the plaintiff has ever given any notice to defendant number 2 for the production of the said power of attorney or call for the production of the said power of attorney for getting the signature verification done through FSL, or even filed any complaint regarding the false and forged power of attorney. Sir, here in the instant case, defendant number 2 is not appeared. So whom I can give notice? If he is appeared through a advocate or a counsel, then it is the opportunity was there for plaintiff to give a notice, but the suit was ex parte. Under the circumstances, though the plaintiff asserted that the said power of attorney
Was it ex parte or right was closed, you said?
So far as ex parte means, defendant number 1 has 2 has not stepped into witness box. Right of the reply was closed.
Right was closed, but it was not ex parte.
But he has not examined him. So far as defendant number 1 is concerned, neither defendant number 1, neither defendant number 2, Your Honor. And
But you could issue a notice to them under Order 12 Rule 8.
but whom, sir? He was not there. He is not appearing. He is not contesting the suit. So opportunity was not there for plaintiff to give a notice, Your Honor. Sir, here in the instant case, sir, posing for a moment, if there is a case of the plaintiff that I have executed power of attorney, my signature was false one or not, it's a different thing here. Here in the instant case, my case is there. I have not executed any document in favor of defendant number 1 to authorize him to execute a sale deed. In spite of the same, defendant number 1 has executed sale deed in favor of defendant number 2. So it is the bounden duty of the defendant number 2 to prove that no power of attorney was executed, and on the basis of that authority, I have executed sale deed. And secondly, sir, what about the possession? possession is required to be proved. The evidence before the honorable court is the effect that possession was not handed over at any point of time to defendant number 1. So how at the time of execution of sale deed, possession was given here
Now possession is
with us.
let us continue our process.
Please.
Yes.
So serial number 10 in criminal board. This application is for Muddamal.
Just 1 minute. Let me take it up one by one.
Oblige.
Bodo ka?
Serial number 10.
એમાં મુદ્દત પૂછજો.
મુદ્દામાલ
અત્યારે વાત કરતો હતો તારીખ વાળી
હવે સાહેબ મુદ્દામાલ બહુ 2003 નો કેસ છે એટલે 2-3 દિવસ સાહેબ આયુએન જોવે છે પ્રાઇમરી શોધ્યો તે મળતો નથી એટલે કદાચ સાહેબ મારું માનવું એવું છે કે આ કેસ અમદાવાદ રૂરલમાં આપણી કોર્ટ હતી 2003માં ત્યારે ડિસાઇડ થયેલો છે એટલે મુદ્દામાલ હવે અહીં પડ્યો છે કે અહીંથી જે મુદ્દામાલ રૂરલનું અલગ થયા પછી ત્યાં ગયો છે એટલે હશે કોર્ટમાં સાહેબ અહીં કોર્ટ હોય તો કાં તો ત્યાં કોર્ટ હોય અને અહીંનું જે જજમેન્ટ આવ્યું એના પછી હાઈકોર્ટમાં અપીલ પણ થઈ છે એ પણ ડિસાઇડ થઈ ગયેલી છે એટલે સાહેબ થોડું આયુએન 2-4 દિવસ જોઈએ છે સાહેબ.
સેટરડે રખ દેતો.
એક તારીખ.
1 તારીખ સેટરડે છે.
જી સર જી સર.
Grateful sir. Oblige.
बाकी कौन सी चार नंबर नाम नहीं है
डायरेक्ट कर लो एलपी डायरेक्ट कर लो तो एलडीसी बात
एलडीसी
बाकी जे ये रखता है
और
वकील ए पंड्या
સાહેબ સાહેબના નિવેદન છે જે દસ્તાવેજ લિસ્ટથી રજૂ કરવાનું
1165 है ना 1166
ઓનલી 1166
आपकी 1166 છે પણ 1165 અને 66 એક જ કેસની છે.
શ્યોર બને
એક જ દિવસ લઈએ આમાં કાલની તારીખ છે
કાલની તારીખ
આવતીકાલે
ઓકે શ્યોર નો પ્રોબ્લેમ
એક જ કેસ છે તો એક સાથે જ લઈએ.
સર સિરિયલ નંબર 11 માં રિપોર્ટ આપવાનું છે સાગામાં
અત્યાર તો મોત
હાજી સાહેબ જમો
વાંધાજી માટે
સર ખબર જ
સરકારી વકીલ
क्या
ફરિયાદી પોતે જ છે.
क्या ऑफेंस कौन सा है इसमें?
ઓફેન્સ 69 है બીએનએસ લગ્ન કરવાની લાલચ આપી શારીરિક સંભોગ કર્યો એ બાબતની.
कब रखे कब रखे
તો સાહેબ એમનો ફરિયાદી આપણે બંને સાહેબ એડવોકેટ છે.
मैडम कब करना है?
અરજી માટે વાંધો નથી.
कब रखूं किस दिन?
મુદત 2-3 દિવસ આપી દો સર.
जामीन है
મારા ખાના સર પણ આજે અમને આજે જ ખબર પડી.
આવતીકાલે
હા સર
एक ही बची ये एंटीसिपेटरी है फिर तो चलो वो नहीं करता 1168 की तो
પાસઠ છે એ બી એક જ ગુનાની છે પેલી કોણ છે 11 65
65 માં મને મુદત માંગી હતી.
હા 7
આવતીકાલે
1168 માં અમારો રિપોર્ટ આવેલો છે.
હા એમાં રિપોર્ટ આવ્યો. 1170 માં રિપોર્ટ.
सुबह लग रहा था कि बहुत सारी हैं आज और आप लेट आ रहे हो, कैसे होंगी? एक भी नहीं है.
એક મિનિટ.
ખાલી 1162 એક બાકી રહી.
સર 1162 માં એવું છે જે જેલમાંથી કરેલી છે ટીએલસી માંથી. પ્લસ સોનીબેન આવતા હતા પણ કંઈક બહાર ગયા છે. એને સાહેબ એની પત્ની ગર્ભવતી છે ને દેવું ચૂકવવાની એવા પર રૂટિનના કારણો લખ્યા છે બહાર નીકળવા માટે. અગાઉ સાહેબ એની જામીન અરજીઓ 2-3 રિજેક્ટ થઈ છે, હાઈકોર્ટે રિજેક્ટ કરી છે. 18 ગુનામાં સંડોવાયેલો આરોપી છે સાહેબ, હેબિચ્યુઅલ ઓફેન્ડન્ટ છે અને 103 સાહેબ મર્ડરનો આરોપી છે સાહેબ. એટલે સાહેબ એને લિબર્ટી નહીં આપવા માટે વિનંતી છે સાહેબ.
ये वो वाला केस है जो भाई का मर्डर किया हुआ है, वही है क्या?
वो पता नहीं है सर, मुझे देखता हूँ।
ये दो भाई और
हाँ हाँ
एक की
हाँ,
वाइफ
वही
ने मिलके
एक सीटर था वो वही है सर.
हाँ अभी 2 दिन पहले था.
મરણ જણાના આરોપી સગા ભાઈ થાય છે સાહેબ, બરાબર છે. કોલમ નંબર 14 માં તો લખેલું છે.
हाँ जी.
जी सर, MSC सीरियल नंबर 24 से जवाब बांटे.
इसमें नंबर बे का रिप्लाई तो आ गया.
हाँ मैंने रिसीव.
बाकी नहीं है.
4 જણા છે ને,
हाँ 4
2 નંબરનો રિપ્લાય આવી.
બાકી ના બાકી સિરિયલ નંબર 25 છે સર. એમાં સાહેબ હું સામાવાળા તરફે અને હું આજે વક્તવ્યનામા સાથે સાહેબ જવાબ રજૂ કરું છું.
सामावड़ा नंबर
3 અને 4. સિરિયલ નંબર 30 છે. એમાં સાહેબ રસદ તરફે
RF सोलंकी.
હા સાહેબ અમે જોઈનમાં છે. पहले
एक नंबर की सर्विस.
जी सर.
नंबर 1 की सर्विस.
जी सर. आई
ના પાછી નથી.
पहली जी सर.
बे में बताइए.
જોઈ લો સાહેબ.
સર સિરિયલ નંબર 8 છે ક્રિમિનલમાં 11 PRM 1166 મેં તો સિનિયર એડવોકેટ સાહેબ બીમાર છે, સિક નો હમણાં ફોન સાહેબ આવ્યો હતો. 1166/26.
अभी तो फिर हुए थे इसमें.
જી સર.
इसमें क्लियर तो हुए थे अभी.
જી સર.
कौन है सीनियर?
ए पंड्या सर, वो बीमार है सर, उनका अभी
लिए तो आए थे अभी.
हाँ
सारे एसोसिएट्स को अलग अलग तो नहीं बोल दिया कि आप चले जाना? वो तो मैंने ही कहा कि कर रहे तुम.
हाँ सर.
खुद ही जाते हैं तो.
આવતીકાલે
पहली तारीख तो
काले जामीन अर्जी है.
सर इफ पॉसिबल है तो एक दिन.
ये पॉसिबल इसलिए नहीं है कि 2 केसेस हैं. अब 2 जामीन अर्जी हैं इसी केस के 2 आरोपियों की. वो कल रखी हुई है.
सर वो सीनियर बीमार है.
अब वो कल देखेंगे क्योंकि वो
सर जी सर.
या फिर उस अर्जी में जो है उनको बुलाओ.
जी सर. बात और
સર સિરિયલ નંબર 4 માં ફરિયાદીને એપેલેન્ટે જે તકરારી ચેકની રકમ હતી એ નામદાર કોર્ટમાં જમા કરાવેલી છે અને સમાધાન કોશિશ અને પૈસા ઉપાડવાની અરજી સાહેબ આપેલી છે.
कहाँ हैं दोनों?
હા
अमरुद जी मफा जी. अरे 2 कैसे हो सकते हैं यार, कोई एक होगा दोनों में से. आप क्यों जी कह रहे हो? आपका नाम अमरुत जी है? फिर अमरुत जी बोलते दोनों हाँ करोगे? ऐसी चीटिंग तो मत करो भाई कोर्ट में खड़े होके। आपका आधार कार्ड दीजिए। समाधान हो गया? 4 लाख में ठीक है, मंजूर है। 4 लाख जमा हो गया, आपको मिल जाएगा। एक बार 80 हुआ, एक बार तुरंत 20।
हाँ पैसे लगवा लो निकले तो क्या
सूचना 25।
और उसकी अन्ना वापिस कर दे। हाँ
सर इसमें रकम तो लिख दो।
आप ही दे
प्रोसेस में रकम तो लिख दो।
समाधान कितना हाँ
पूरे पूरी 4 लाख। अरे अरे 30,000 बाकी है। अरविंद भाई 30,000 बाकी है હવે। 30,000 और आपो ना। Cost at the rate of 7.5% as per the judgment of Supreme Court.
प्लीज
સાહેબ સિનિયર છે PR પટેલ એટલે આવે તે સાહેબ
बुला लो।
જી
अभी चलो सर
हाँ जी सर। दलील
सिविल अपील में
सर एक रिसेस से पहले सुन रहा था, वो थोड़ी सी बाकी है।
कोई बात नहीं, जल्दी नहीं।
ज्यादा नहीं हो गया, उसमें 5-10 मिनट ही शायद हो गए, उसके बाद लेता हूँ।
सिविल बोर्ड में 34 नंबर है एप्लीकेंट
जी
जी सर। हाँ सर उसमें जॉब उनको आ गया है सर।
जवाब तो आ गया, लेकिन 3
हाँ
जो सामावाड़ा है वो गुजरी गया।
गुजरी ગયા છે સર તેમના વારસો માટે છે જોઈ સર એકવાર ઇન્ક્વાયરી કરી લો
उन तीनों के अगेंस्ट अपील आपकी अबेट हो गई।
जी
एक को 7-8 साल हो गए, एक को 5 साल हो गए,
हाँ
और एक को 2 साल से ऊपर हो गए। तो इन तीनों के अगेंस्ट तो अपील अबेट हो चुकी। बाकियों का क्या करना है?
नेक्स्ट डेट पे सर हियरिंग कर
आज नहीं?
हाँ
ठीक है। 32
जी
जी, किसके लिए आप?
मैं अपेलेंट कर रहा हूँ
सर इसमें आपकी एक और अपील है जो फर्स्ट को है, और
ठीक।
सॉरी ये सीएम है, वो अपील है।
वो अपनी
इसको भी फर्स्ट में रख दिया साथ ही,
ठीक है
दोनों एक ही दिन हो जाए।
उसमें सर प्रोडक्शन ले रहा हूँ मैं अभी
उसी दिन दे देना साथ ही।
अभी हाँ जी रजू करो, मैं सामने वाले को भी रिसीव करवा दिया।
ठीक है भैया।
ये सिविल सवाल मेंशन करें અત્યારે પ્રોસીડ કરવા
थोड़ी देर वेट करनी पड़ेगी।
जी सर, प्लीज यू। So we are on page number 13 of the judgment. So far as the findings given by the trial court to that effect that power of attorney is not coming on record. In my humble submission, Your Honor has rightly said that burden is upon the plaintiff to vouch for the same. But here in the instant case, your plaintiff stepped into witness box and in verbatim term, he stated that I have not executed any power of attorney. In cross-examination, nothing come out from the mouth of the plaintiff, which helpful to the defendant. So initial burden was discharged.
But tell me one thing,
Please,
your prayer, one of your prayer, that's I think second prayer,
please,
is to declare this
power of
power
attorney
attorney
is
as null and void
null and
as
void.
you have not executed it.
Please.
In the absence of either the original or the copy, can the court declare?
So there is an implied presumption on the part of the court, because in observation made by the trial court, it was also impliedly honorable court come to the conclusion that there is no record. Power of attorney is not coming on the record.
Yes.
Therefore, it can be said that it is a genuine power of attorney.
I'm not saying so. My query is whether in the absence of power attorney, there is no either original or copy on record. Can the court declare it?
100%, because the first prayer is.
There is no presumption that some power attorney is in existence.
Please.
There cannot be any presumption regarding that.
Because there is no document.
If there is no document, how the court declare it null and void?
My first prayer is with regard to cell deed.
Cell deed is all right. I am not on
The
that.
cell deed, my humble submission to that effect that my case is that the cell deed is without authority. If honorable court come to the conclusion that there is no authority on the part of defendant number 1, then honorable court can partly allow my suit and set aside a cell deed. Your Honor.
Court has not come to that conclusion. Court said it is not on record. I cannot pass any
100%.
order.
But it is the bounden duty of the defendant, Your Honor. Because defendant number 2 is a beneficiary. Here in the instant case, who is the beneficiary? Defendant number 2 is the beneficiary on the basis of valid cell deed, Your Honor.
But whether the plaintiff has to stand on its own legs or what?
100%. But initial burden is discharged. In my humble submission, I have stepped into witness box. I have stated on oath that I have not executed any power of attorney in favor of defendant number 1. In cross-examination, nothing is come out from my mouth that no, the case put forward by the plaintiff is wrong. Thereafter, sir, burden shift on the defendant. Secondly, Your Honor, as per order 8 Rule 5, defendant has to deny the averments made in the plaint, Your Honor.
That has not been denied.
That is not been denied. So it can be said to be there is a deemed admission on the part of defendant number 1 and 2, Your Honor. And thereafter, sir, my further submission to that effect that defendant number 2 is a beneficiary on the basis of alleged cell deed.
If the party appears, denies some of the facts, does not deny any 1 or 2 facts, it can be presumed that those facts are admitted.
But
once a party either does not appear or appears and does not file any reply,
please,
in that case, there is no presumption that every fact is admitted.
But so far as
had it been so, there was no requirement of any evidence.
Sir, here in the instant case, Your Honor has to see this, that defendant number 4 is appeal. Who is the subsequent purchaser?
His subsequent purchaser.
That cell deed is also challenged by way of amendment, Your Honor.
When it is alleged that power attorney was executed, he was not there.
He was not there.
So
but
he is not in a position to say anything about that.
It is the duty of the defendant number 4 to produce the power of attorney because he is coming before the court and stated that I am the bona fide purchaser. So burden lies upon him to prove that he is the bona fide purchaser. And for that purpose, he has to establish nexus between defendant number 1 and defendant number 2 transaction. Because defendant number 4 is coming before the honorable court and saying that no, I am the bona fide purchaser because I have purchased the land in the year 2008. I am the subsequent purchaser and I have searched the cause of sub-register, and from where I came to know that originally 1996 sale deed was executed in favor of defendant number 2. But the sale deed was executed on the basis of power, Your Honor. And it can be presumed that original document must be handed over to defendant number 4 at the time of subsequent sale deed. But defendant number 4 also does not step into witness box here. So we have to see hold the nexus here. So in my humble submission, I have discharged my initial burden. Thereafter, burden shift upon defendant number 1, 2, and 4, but that burden is not discharged here. If they discharge, then obviously burden will again shift upon me here. Therefore,
that is not the burden, that is onus.
I'm sorry.
Burden never shifts.
Burden never shifts. Onus
Onus
required.
shifts.
Please. And second observation was made that I have not made any criminal complaint, but that complaint was filed and it is produced at Exhibit 108 here. Gandhinagar police station plaintiff has lodged a complaint about the fraudulent sale deed. So this observation, while observing this, honorable court has overlooked Exhibit 108 here.
That is against?
That is against defendant number 1 and 2.
And what the complaint says?
Please, sir. Exhibit 108. સામાવાળા જીતેન્દ્ર રમણલાલ and રાકેશ કનૈયાલાલ જાની બોગસ દસ્તાવેજો ઉભા કરી મિલકતનું વેચાણ કરી વિશ્વાસઘાત તથા છેતરપિંડી કરી તેવા બોગસ દસ્તાવેજોના આધારે મિલકતનો ખોટો વેચાણ દસ્તાવેજ કરાવવા બદલ ફરિયાદ અરજી.
When it was filed?
It was filed Tariq is missing. Date is not there. Date is not mentioned.
You must be knowing the date when you had filed it.
100%, but it was not written in the complaint here. Date is blank here. In the document 108, date is not there. But it was filed here.
Whether it was before filing of the suit, after filing of the suit, after objection of the other party, when it was.
Yeah, it is silent. The complaint was filed, but it is silent about the date.
It is mentioned in your plaint.
Yes. Yes, sir. On page 4. Last 3 line. કે પ્રતિવાદી નંબર 1 અને 2 ના એકબીજાના મેળાપીપણામાં વાદીની દાવાવાળી મિલકત સંબંધે ગેરકાયદેસર રીતે વેચાણ વ્યવહાર કરવામાં આવેલ છે તે વેચાણ વ્યવહાર બાબતે અમો વાદીએ લેખિતમાં પોલીસ ફરિયાદ આપેલ છે, જેની આ નકલ સાથેના અલગ લિસ્ટથી રજૂ કરેલ છે. So it was mentioned.
Page number 8.
Page 4, પેરા 4 ની લાસ્ટ 3 લાઈન, પેરા 5 ની સાહેબ પહેલી લાઈન ઉપર લાસ્ટ 3 લાઈન. So these averments and the complaint produced at 108 was overlooked by the trial court, while observing that no criminal complaint was filed. And further, sir, so far as other observation is concerned, on page 13, after I read that under the circumstances though, 7th line, under the circumstances though the plaintiff asserted that the said power of attorney is forged and falsely created by the defendant number 1 and prayed for cancellation of the sale deed, but the said power of attorney itself has not been brought on record, nor that appears there have been any effort of being the power of attorney on record from the plaintiff's side. Therefore, the assertion that the power of attorney dated 29/3/1996 is false and forged appears to be bare word of the plaintiff, but no evidence to prove the same has been produced by the plaintiff on record. On contrary, from the sale deed on number 209996, it appears that it registered sale deed and based on the power of attorney of the plaintiff, same has been executed before the registrar under the circumstances when the document in question not being in record, and except for the bare word of the plaintiff, there is nothing on record to prove that the document is forged and false. The say of the plaintiff that the defendant prepared false and forged power of attorney of the plaintiff is not tenable. Hence, I answer issue number 1 in the negative. So,
The
honorable-
one line which you read,
please, Your Honor.
nor there appears that there have been any effort to bring the power of attorney on record from the plaintiff side.
100%.
Have you made any effort?
There is no effort on the record here. There is no effort.
Then
But once again, I am saying that because, sir, I am relying upon the judgment of Honorable Gujarat High Court. The judgment says that once who is benefited from the transaction, and if one is alleged that this transaction is sham and bogus and executed on the basis of fraud power of attorney, that is the bounden duty of the beneficiary to prove that no, this is a genuine transaction. Once I am stated and I'm stepped into witness box, it is the bounden duty of the defendant number 1 to 4 to prove that the earlier transaction of 1996 is a genuine transaction. And secondly, Your Honor, so far as possession is concerned, there is a general principle that possession is follow the title. There is the general principle. But here in the instant case, from documentary evidence on Honorable Court come to the conclusion that possession was not handed over at the time of execution of Banakat, Your Honor. In spite of the same, there is a assertion with regard to possession in sale deed, Your Honor. Secondly, Your Honor, that principle is only applied when there is a genuine transaction. Here in the instant case, I am so attacking on the authority of defendant number 1 to execute a sale deed in favor of defendant number 2. So when the basis of title is in question and it can be said to be not a genuine document, then possession cannot be followed the title. Now, sir, so far as legal aspect is concerned, I am relied upon certain judgment. First judgment, I am relied only for that aspect that બનાવી દઉં પછી that my suit is within the period of limitation. Why? Because
There is no issue on that.
there is no issue, but only because my suit is based upon a fraud. So from the knowledge of the fraud, I have obtained the knowledge in the year 2005. I have filed the suit in the year 2006.
That's why there is no issue.
Please, Your Honor. Second judgment is of 2013 Supreme Court, 2028. Emma Head C is there. Section 101, 102, 103, and 104. Honors of proof. Document execution denied or alleged to be due to undue influence or fraud, or under suspicious circumstances. Honors lies on the propounder of document and on person in dominant position in case of undue influence. Same would apply in case of fraud here. Here in the instant case, who is the dominant person? Defendant number 4 can be said to be a dominant person who can be said to be owned the original power of attorney.
Dominant person in cases of undue influence. There is no undue influence in this case.
But there is no undue influence, but I am relied upon this judgment
Then
in
how
respect
there
of,
can be a dominant position.
because sir, I have already stated that at the time of execution of subsequent sale deed, obviously સાહેબ જે અગાઉના ડોક્યુમેન્ટ છે બધા એમને આપેલા જ હોય.
આપેલા જ હોય, that's all right.
અને બીજી વસ્તુ સર,
But
he has not
your
stepped into
case-
witness box.
in your case, there is no undue influence, and so no person in dominant position.
So far as
Dominant position is only in case of undue influence.
my submission with this, Your Honor, why is can be said to be a dominant person? Because the original document or original power of attorney must lie with him.
Sir, he can be in a better position to file it.
Better,
But
he
he
is the
cannot be a
only
dominant.
he is the only person who can file it.
But that is not the
Because it is
dominant-
not a registered document, Your Honor.
But don't use that the words dominant position for him. Dominant position is only in case of undue influence.
Supposing for a moment,
A person who is in a dominant position can
100%. But
This
here
is
in
not
the
undue
instant case,
influence.
in view of this scenario here, who is the person who can have the power of attorney?
that is something
is-
else, sir. The word
That is defendant number 2 or defendant number 4, Your Honor.
the words dominant position cannot be used for them.
The next judgment is 2022 AIJEL 243978. Emma sir, head note C. Principle as to burden of proof. Though burden of proving fraud lies on person alleging it, fraud is not capable of being established by positive and tangible proof. Therefore, it is sufficient if evidence given in such as may lead to an inference that fraud must have been committed. In present case, it was for defendant number 1, 2, and 3 to prove that document and transaction in question was bona fide and genuine. Thus, only when defendants could have proved so, then plaintiff was to dislodge them by proving that it were sham, bogus, and fictitious. Case before the trial court was for appreciation of fact and circumstances where none of the parties have preferred to produce or bring on record original document. The next judgment is 2019, Your Honor. And એમાં પણ સાહેબ, the honorable court was of the opinion that burden to prove that alleged power of attorney is not a result of fraud and misrepresentation lies on a shoulder of appellant defendant because they are beneficiary, and trial court and first appellate court has committed a manifest error in shifting burden on shoulders of plaintiff first respondent. અહીંયા પણ સાહેબ એમનું કેવો એવો if their case is that no, power of attorney is genuine because they are availing benefit on the basis of power of attorney, Your Honor. So the burden always lies upon them to prove that thing. And the next judgment is 2007 Supreme Court, Your Honor. I am only relied upon this judgment for non-examination. That adverse inference is required to be drawn here. Here in the instant case, neither defendant number 1 and 2 nor defendant number 4 have stepped into witness box. And the last judgment is 2026 Gujarat High Court, Your Honor. Emma sir, head note D, agency, power of attorney, date of execution. Here in the instance, there is no date of execution. A power of attorney stand terminate upon the date of its execution, and any sale deed executed by power of attorney after the date of the execution is void. Defendant number 2 and 3 claimed title through a registered sale deed dated 25/9/2009, executed by defendant number 1 as alleged power of attorney holder whereas the executor of the power of attorney dies on 22/1/2003. Sir, now important. Neither a copy of the power of attorney was produced on record, nor was the sale consideration paid to the original owner during his lifetime. Else the sale deed was void and title did not pass to defendant number 2 and 3. And Emma said, I have marked the para 12.1, 12.2, 13 and 13.1. I have marked. (13.1) says that thus in the absence of the copy of the power of attorney or having been not been registered, which otherwise requires if it was coupled with interest, it in any eventuality, the defendant number 2 and 3 cannot be allowed to retain the possession of the suit property as the title of the suit property was not passed on in their favor on the strength of the sale deed.
That is not your case.
Sir,
Sir, possession
I am
is-
relying upon this judgment because, posing for a moment, if there is a power of attorney, then that power of attorney can be said to be coupled with interest because it was executed only that Banakat was there in favor of defendant number 1. So that power of attorney is required to be registered. And if it is registered, then I might have produced the same, but it was not registered. Please,
Do one thing, make a list,
please,
flag the first page of the judgments and highlight the relevant portion.
please.
August 24th.
Please.
हाँ जी सर.
Serial number
Serial number
38, civil.
then last.
This is an appeal filed by the plaintiff against
वकील
the
श्री आर
rejection
पांडे.
of the suit.
शांति भाई.
वकील जी आरे पंड्या.
So everything is on record because this matter was heard earlier. It was heard on 30 January 2026. Subsequently, it was kept for an order. However, no order was passed due to the transfer of the honorable judge. So my
It is order below exhibit 9 which has been challenged.
Yes, sir. Below exhibit 9, 711 application was filed by the defendant number 6 to 9. However, there are more defendants, but only 6 to 9 filed that application.
That was
Honorable
allowed.
trial court was pleased to reject the suit, and that is why I am on my legs before this honorable court. Challenging the order, impugn order passed by learned trial judge. Now, sir, before I enter into the merits of the case as far as factual aspect is concerned, I would like to highlight the blunder or legal error committed by the trial court. That is why I am requesting to this honorable court to please have a look at page number, para number 8 of the impugned judgment.
Don't say blunder.
I'm sorry about that, but sir, it is. And that is why.
Yes.
Para number 8 of the impugned order.
Para
Para 8. Yes, sir. Para 8 of the impugned order. That is annexure A of my appeal.
on page 4.
Yes, sir.
Hmm.
Because para number 8 and 9 or onwards, I would rather say, these are the observations of honorable
What are
trial.
the facts? Tell me
Yes.
the facts, only then I can appreciate this.
Facts, as far as facts is concerned, I'm co-partners. I'm lady co-partners, and my legal rights acquired by bond are violated. Defendant number, sir, I would like to address defendant and plaintiff because appellant is the plaintiff and respondent are the defendant. So, defendant number 1, 2, 3 sold the very land to the defendant number 4, 5 and onwards. 4, 5 also sold the land to the 6 and 9. My co-personal rights as far as the suit land is concerned, which has been acquired by my birth, is violated, and that is why I filed the suit. This is the, sir, facts in one line. Ignoring all these facts, ignoring all the written arguments as well as oral arguments and the judgments of Honorable Gujarat High Court and Supreme Courts, trial court passed an order rejecting the suit. Can I, sir, now
What's the ground in 711?
delay? That is the main ground. Limitation. Limitation is the main ground, entire. As far as sir 711 is concerned, that is annexure B. Annexure B is the 711. Wherein it is the of only 4 pages. From 4 pages, para number 1, 2, 3, 4. These are all my facts as stated in this plaint. I have already stated in the plaint, but they said that વાદીએ લખેલું છે. So, para number 8 and before. I would like to highlight para number 8 first. To satisfy the query of this honorable court, what are the grounds? First ground is limitation. Now, second ground, this 711 is filed under order 7 rule 11 and D. A is not applicable, even D is not applicable. Why? I'm going to satisfy the consensus of this honorable court. Before I read this, sir, para number 8 of 711, wherein it is said, દાવા સદર દાવાના કામે વાદીના પિતા દ્વારા દાવાવાળી જમીનનો રજિસ્ટર નંબર 100 પ્રતિવાદી નંબર 4 થી 9 ની તરફેણમાં કરી આપેલ છે. જે વેચાણ દસ્તાવેજ બાબતે હિન્દુ સક્સેશન એક્ટની જોગવાઈઓ અન્વયે और ધ્યાને લેતા જ્યાં સુધી પિતાની હયાતી હોય અને તેઓ દ્વારા તેઓની હયાતીમાં કોઈ વેચાણ વ્યવહાર કરવામાં આવેલ ન હોય તો તે બાબતે તેના વારસદારો રોકી શકે નહીં. આવેલ હોય તો તે બાબતે તેઓ રોકી શકે નહીં. વારસદારો રોકી શકે નહીં. અને જ્યાં સુધી હિન્દુ અવિભક્ત કુટુંબના કર્તા તરીકે કોઈ વેચાણ દસ્તાવેજ કરવામાં આવેલ હોય તો કર્તાની હયાતીમાં અન્ય વારસદારોનો કોઈ હક અધિકાર પોસાતો આવતો ન હોય અને સન 1981 દાવાવાળી જમીન પરત્વે વાદીઓનો કોઈ કાયદેસરનો હક હિસ્સો પોસાતો ન હોવાથી ઓર્ડર 7 રૂલ 11 ની અમને અરજી આપી રદ થવાને પાત્ર છે. હવે સર, this is the facts as per the pleading made in 711 in para number 8. Now there is no such fact mentioned in my plaint. Only and only averment made in the plaint is required to be considered. That is a subtle principle of law as far as the adjudication of 711 is concerned. There is no such fact. Even in the cell deed, there is no such fact કે હું અવિભક્ત હિન્દુ અવિભક્ત કુટુંબનો કર્તા તરીકે મેં આ જમીન વેચી, એવું કશું છે જ નહીં. રેકોર્ડ બોલે છે સાહેબ. Hence, even I made an argument before the trial court, but trial court has not considered this argument. And now, sir, after reading this, para number 8 of the impugn order, wherein trial court has committed an error of law. There are two types of errors: error of law, error of facts. As the observation made by the trial court in para number 8, 9 and 10, rest of the paragraph number, that is from para number 1 to 7, these are the factual aspects or the arguments canvassed by both the sides. But the observation made from para number 8 of the impugn order, wherein neither of this, that is plaintiff and defendant, cited this judgment of Honorable Gujarat High Court Bardoli judgment. Trial court, relying upon this judgment, even trial court has mentioned this judgment in para number 8. I'm going to read this paragraph.
Court can. What is harm in it?
But sir, court can. I never deny. I never deny court cannot. But what is?
You are saying none of the parties have
Yes, sir.
mentioned it.
None of the party,
Even then the court has
none of
relied.
the party has relied upon court itself, and court can. That is why now I am going to say that even though court has relied upon, court has committed an error. That is the my crux or intention to say this. Para number 8, sir. I'm now, with the kind permission of this honorable court, para number 8. I'm going to read. Considering the facts and circumstances of the case, it appears just and proper to discuss all the disputes pertaining to the rejection of the plaint concurrently, that is cause of action and barred by law, so as to avoid unnecessary repetition for the sake of brevity. Now, so as to understand when the cause of action arises, it required to go through the below mentioned principle laid down by the Honorable Supreme Court as well as Gujarat High Court. It has been held by the Honorable Supreme Court in the case of so and so. Now, the state of Punjab and Gurudev Singh, right to sue. Now, Honorable trial court has depicted that paragraph from that particular judgment. The word right to sue means the right to seek relief by means of all legal proceedings. The right to sue accrues only when the cause of action arises. The suit must be instituted when the right asserted in the suit is infringed, or when there is a clear and unequivocal threat to infringe such right by defendant against whom the suit is instituted. Further, it has been held by the Honorable Gujarat High Court. Now it is very important paragraph. In the case of Bardoli Srirang versus Mahesh Bhai, Babu Bhai and others, in para number 40, relying upon the judgment, para number 40. Sir,
just 1 minute, sir. एरन पुरिया साहब, लगता नहीं कि आज सुन पाऊंगा, टाइम हो जाएगा. Sword, no.
The trial court, relying upon the para number 40 of the judgment. Now, my request to this honorable court to have a look at the Bardoli judgment at para number 40. Which has been submitted by me, and it is part and parcel of the record. Sir, મેં એમાં મૂકેલું છે સાહેબ જજમેન્ટ. Bardoli Srirang, list of judgments on behalf of appellants. I have also submitted my points of argument before appellate court. And along with that argument, I have submitted all these judgment. First judgment, Bardoli judgment. What is that? Bardoli judgment, para number 40. अलग थी appeal हाँ एक सेप बारडोली पैरा नंबर 40 I believe that honorable trial court read this judgment entirely. I also believe that honorable trial court has also read para number 1 of the judgment, para number 41 and 45 of the judgment. And now I am going to read this entire paragraph of Bardoli judgment, para number 40. The issue of limitation may be addressed.
You want to say it is mixed question of facts and law?
It is said mixed question of facts and law. Yes, it is very clear. Now, para number 8 on page number, running page number 5. Yes.
Five of
Is
impugned judgment.
impugned judgment. That is page number, para number 8. Wherein Bardoli judgment is cited along with that particular paragraph. Sir, in my humble or respectful
You
submission.
want to say last line of that para is not taken?
Yes. Why? That is the crux of that judgment. If honorable trial court has read everything, it should have mentioned, it should have been mentioned. That is the that is the error of law. Trial court committed this error of law. Because what is the observation of the Honorable Division Bench of Gujarat High Court in that judgment? In these premises, last paragraph, last line of para number 40, there are 3 premises, A, B, and C, the cause of action, where the cause of action commenced and the result of non-action of the plaintiff. These are the 3 premises. In these premises, the question of limitation cannot be called a pure question of law. It would rather be a mixed question of facts and law.
Sometimes it is not.
That line has not been mentioned and in entire judgment or order.
Yes.
So that is an error of law. Now, sir, please go to running page number 170.
I'm not saying about this case, but let us take up this thing only. The question of limitation cannot be called a pure question of law. It would rather be mixed question of law and fact.
Yes. That is the observation made by Gujarat High Court.
It is
Honorable Gujarat High Court
made very rightly. We cannot dispute it. It is a mixed question of law and fact.
It is not
But-
disputed.
Let me
Okay,
complete my.
please. I'm sorry.
But if from the plaint,
Yes.
it can be seen on the basis of facts mentioned in the plaint
Yes.
that it is barred by law
Yes.
or barred by a limitation,
Yes.
then is the court required to allow the parties to lead evidence once it is clear from the plaint itself?
Plaint itself, the answer is no. But from the plaint itself, if it is
Plaints and documents.
document, naturally, nothing is seen. Nothing is seen except plaint and documents.
Hmm.
Nothing is seen as far as 711 is concerned.
And if from the plaint itself, it can be concluded
Okay, yes, it is barred by law. Then
Yes.
suit goes home naturally.
on the basis of facts mentioned in the
Yes,
plaint.
sir. I do agree. That is the principle, basic principle. But
It is a mixed question of fact and law, but in 711, facts mentioned in the plaint are to be seen. And if from those facts only, it can be concluded, then
if it is a pure question of law, then order 14 is there in CPC.
it is not pure question of law. It is mixed question of law and fact.
Then suit cannot be rejected.
But from the facts mentioned in the plaint only,
From the facts mentioned in the plaint only, if the suit is barred by law, from the plaint mentioned,
Yes,
then yes. If it
that's
is
what I'm
not,
saying.
if it is not, then it cannot.
That's what I'm saying.
Yes,
sir.
sir. Yeah, this is pretty, I
For
don't.
example, if the plaint itself mentions that cause of action arose in 2000 and the suit is filed in 2015,
Ha.
it is a mixed question of law and fact, I agree.
Yes,
But it can be rejected at 711.
but sir, relying upon the judgment of Gujarat High Court Division Bench and the conclusion part is not mentioned, that is an error of law, and that is why I am standing before this honorable court. The trial court has committed an
Let's come
error.
to the facts stated in the plaint,
Yes, sir.
whether
Now,
it is clear from plaint or not.
yes, sir.
That's
But
the
sir,
main point.
before I, that is why I made one request that before I go to the enter into the merits of the case, I would like to highlight the error of law that trial court has committed. And that I have already highlighted this error because in para number 8, trial court relying upon para number 40, and based on that para number 8, entire para number 9 is discussed. So when it is the error of law, the discussion made in para number 9 goes away of the impugned judgment. Because first line, keeping in mind the aforesaid principle. What was the aforesaid principle? It is a question of fact. It is a mixed question of facts and law. That was the principle laid down by Gujarat High Court in this Bardoli judgment. And that observation was not mentioned everywhere, anywhere. Then it is a fact. It is misinterpretation of the judgment. It is an error of law committed by the trial court. And that is why the entire keeping in mind the aforesaid principle, para number whatever what has been observed by the trial court in para number 9 has no relevance. Now, sir, when there is no relevancy of the observation committed by the trial, observation made by the trial court, my suit revives. There is no alternative, or there is or one. I committed. I have observed, sir, three error of law. One, this Bardoli judgment. Second, sir, running page number 173. મારી જે પેલી આ છે appeal, એમાં સાહેબ running page number 173, and read that may be read with impugned judgment, para number 10, para number 10G. Para number 10G. And page number 173.
Para number?
Para number 10G of the impugned order. 10 subclause Z. On page number 10. Page number 10 and 11. Running page number, sir, in my appeal, 8. Hmm. 10 and 11 of my appeal. Now, wherein this may be read with page number 173. This may be read with page number 173. That is error of law committed by the trial court. Wherein in page number 10G, one judgment which has been relied upon by the plaintiff, Balsaria Construction versus so and so. The plaintiff emphasized on para number 4 and 8, which involves on the issue that plaint cannot be rejected on the ground that it is barred by limitation. As limitation, although the facts and circumstances are not in line with that, the present case, the same has been applied. The present case, but has not aided the plaintiff. However, in the said in the very said para number 7. Para number 7 of that judgment, sir. That is on page number 173. It has been expressed by the Honorable Supreme Court the issue as absolute proposition that an application under Order 7, Rule 11 can never be based on law of limitation is an academic question. That is an error committed by the trial court. That is the, now sir, para number 7 of that particular judgment of Honorable Supreme Court on page number 173. May I read, sir? In view of the statement made by the counsel of the parties, the bench held that the question referred to the larger bench was academic so far as this case is concerned, and accordingly declined to decide the question. The case was sent back to the bench for disposal on merits based on the facts of the case. Where is that observation made by the trial court, mentioned in para number 10G, that an absolute, that the issue and absolute proposition that an application under Order 711 can never be based on limitation is an academic question. No such observation made by Honorable Supreme Court as far as para number 7 of that particular judgment is concerned. તો લાયા ક્યાંથી સાહેબ ટ્રાયલ કોર્ટ? આવું ક્યાંય છે જ નહીં, જજમેન્ટમાં જ નથી.
Sir, read para 6 and 7 together.
Together. Para number 6. It cannot be, it is not the case of either side that an absolute proposition, an application under 711 Rule D can never be based on the limitation. Both sides state that the impugned judgment is based on the facts and of this particular case, and the question whether or not an application under 711 could be based on limitation was not raised and has not been dealt with. Both sides further state that the decision in this case would depend upon the facts of the case. Even otherwise, if I read, because trial court has quoted that particular paragraph, particular words, but no such word has been found in the judgment of Honorable Supreme Court. And the observation, obiter dicta and ratio decidendi. Ratio decidendi is required to be considered and not obiter dicta. Here there is no such case. What is ratio decidendi? That is mentioned in para number 4. That is a mixed question of facts and law, and averment made if the plaintiff is required to be considered. That was the observation made by the Honorable Supreme Court in that particular judgment. Now, relying upon that judgment, trial court has committed an error of law. Now, sir, further, one more important, para number 10A of the impugned judgment. The second error, now third error, para number 10A of the impugned judgment. Para number 10A, that is Saranpal Court judgment. That may be read with para number, running page number 126. Now here it is notable that this court has humbly taken into the consideration all the judgments placed by the plaintiff in reliance of the plaintiff. I have submitted this judgment before the trial court. Saranpal call versus so and so. It has been argued by the plaintiff that present matter is similar to that of the present case, and that is sub judice before honorable, and so so as such, when the adjudication of similar issue is pending, then plaint cannot be rejected. That was the submission before the trial. And it has been mentioned in my ground N2R of my appeal. Now, sir, upon careful, the word is used, careful scrutiny of the said case, it appears that the facts and circumstances of the case are not totally aligned with that of the present case, as here the plaintiff's father has jointly executed the sale deed of their ancestral joint property of in his lifetime, which is not the concurrent with the facts of the said case. Moreover, there the matter had differing views and has referred to the larger bench, correct, emphasizing majorly on the technical points. Now, sir, I take a pause for a moment, emphasizing majorly on the technical point of substantive question of law. Can it be considered as technical point when there is a question of substantive question of law? The answer is no. Whether the trial court could have framed the preliminary issue under order 14 rule 2 with regard to limitation for the purpose of rejection of the plaint, and whether the written submission and the document filed by the defendant can be referred while determination of order 7 rule 11 application. Whereas હવે સાહેબ ફાઇન્ડિંગ આવે છે એમનું, whereas that is not the case in the present matter. Moreover, હવે finding સાહેબ હવે, it has been expressly clarified by the honorable court in para number 27 into bracket page number 43 of the said case, that it is made clear that the court has not expressed any opinion either on the issue of limitation or on the merits of the suit. So the said judgment is anyway does not aid the plaintiff against the plaintiff. Now, sir, with regard to this observation made by the honorable trial court, I'm requesting to this honorable court to have a look on page number, running page number 126. Para number 27. Because trial court has relied upon para number 27 of that particular judgment. Para number 20, I'm sir going to read that para number 27. In that view, the matter, the scope, ambit, and the parameters of deciding an application of rejection of the plaint under order 7 rule 11D, deciding the preliminary issue on pure question of law under order 14 rule 2 subclause 2, and for pronouncing a judgment on admission under order 12 rule 6 being absolutely different and independent of each other, single bench and division bench were required to strictly adhere to the procedures laid down in the said provisions, and could not have exercised inherent power or suo motu powers beyond the specific provisions contained in the code. The impugned orders passed by the High Court being in the utter disregard to the said provision and of the settled legal position deserves to be caused and the set aside and are accordingly set aside. The suit is restored. This is the observation made by the deferred observer, no doubt deferred, but made by the Belaben Trivedi, Justice. The suit is restored on the file of the single bench. The bench is directed to proceed with the suit in accordance with the law. Now, observe, having read this particular paragraph on page number 126, para number 27, and thereafter this paragraph, trial court says that it is a technical issue. That is an error of law committed by the trial court. Now, sir, para number 8. As far as para number 10B. and set 10G. Page number 173, I have just stated page number 173. Wherein Honorable Trial Court on page number, para number 10G. Again, sir, I'm an academic question. Honorable Trial Court in para number 10G, last line, observed that, however, in the very said case, para number 7, it has been expressed by the Honorable Trial Supreme Court that the said issue an absolute proposition that an application under 7 Rule 11 can never be based on limitation. It is an academic question. Now, sir, how trial court observed that it is an academic question? It is land of law, Article 141. So trial court cannot go beyond 141, Article 141, stating that it is an academic question. It is the judgment of Honorable Supreme Court. And that is why I said that it is a error of law 1, 2, 3. Now, sir, considering these 3 errors, is it not sufficient that matter should be remanded back for fresh hearing? I'm not touching the facts. I'm only touching right now. I'm going to touch the facts. I'm only touching the law. Because trial court has misinterpreted the entire judgments. 1, 2, 3, 4. Again, sir, para number 10. It's my humble request to this honorable court to have a look. Annexure G, that is my Annexure G. Para number 10, read with Annexure G, but para number 10, wherein trial court has tried its level best to deal with all the judgments. In way. How? My first judgment on para number 10. Saranpal, that is done. Now, para number 10B. Para number 10B. Para number 10B, sir, Salim Bhai versus State of Maharashtra. I relied upon that judgment. What was the observation of the trial court? Plaintiff has emphasized on para number 9 of the said case that for the determination of Order 7 Rule 11, only the averment of the plaintiff are to be considered, and that pleas taken by the defendant in written statement would wholly irrelevant. The said ratio has been squarely applied to the present case. To the present case, meaning the case was in hand. Although the same has not added the plaintiff against the present application. Why? Without reason? No logic, nothing. On one hand, Honorable Trial Court has agreed with that particular ratio laid down by Honorable Supreme Court. On the very second line, although it has not been added to the plaintiff, without giving any reasons, okay, why it has not been added, why it was not helpful. No reason was mentioned. Once the ratio has been admitted, then it is in the part of the plaintiff. It is helpful to the plaintiff. See, Vishwanath Bank, the same thing. Para number 7, everywhere, sir, everywhere. Para number 10C. The plaintiff emphasized para number 7 of the said judgment, Vishwanath judgment, for determination of so and so should be isolated. The ratio laid down has been squarely applied. Copy, paste. the ratio laid down, the same ratio, the same word, ditto to ditto. The ratio has been, the said ratio has been squarely applied to the present case. If the ratio has been applied to the present case squarely, the word is used squarely, then why in the second line, although the same has not been, has not added to the plaintiff against the present application? D, Sejal glass, which is very important judgment, because the 711 was filed by 6 to 9. What about my right to sue against 1 to 5? That was the observation made by Honorable Supreme Court in Sejal glass. The ratio laid down has been squarely applied. Again, there is no question of rejecting the plaintiff partly in the case. Suit cannot be rejected partly, and that is why I am going to reject the suit entirely. That was the observation. But my respectful submission was that, and is that, sir, application under Order 7 Rule 11 was filed by certain defendants and not by all the defendants. What about my right to sue against 1 to 5? 6 to 9 was filed.
Sir, if the plaint is barred by limitation, I'm not saying at the stage our order is proper or not, but only talking about this argument.
Correct.
If the plaint is barred by limitation, it is against all the defendants, not only 6 to
But
9.
what about my right to sue remains?
Which right to sue?
Against 1 to 5.
If it is barred by limitation, then which right?
Then they have to file. They didn't file.
But that is not the case.
No, sir, that is the issue, and that is the issue before Honorable Supreme Court in Sejal glass in para number 10. And observation of, sir.
Sir, now you are misinterpreting it.
No, sir. I'm not. I'm trying my best to assist this Honorable Court. Sir, let us read para number 10 of that judgment.
The thing that plaint cannot be rejected partly.
Partly.
It doesn't mean.
But it is specially.
Against some of the defendants.
It is mentioned. It is specially mentioned. It is specially mentioned in para number 10 of the judgment. That for it cannot be rejected partially and for certain defendants. It is mentioned in the judgment, sir.
Read it.
Yes, sir. પહેલા હું સાહેબ આ પેરેગ્રાફ સેજલ એમનું જે એરર છે એ બતાવી દો. The plaintiff has emphasized on para number 10, which involves on the issue that the plaint cannot be rejected partially or partly. The said ratio has also been squarely applied again to the present case. If so, there is no question of rejecting the plaint partly in the present case. So the same has not been added to the plaint. That is the misinterpretation of the judgment or the ratio laid down by Honorable Supreme Court in Sejal glass. Now, sir, Sejal glass વાળું judgment I am going to read.
It is on page.
There is a bunch of judgment along with my written argument, wherein Sejal glass is at point
61
number
to 67.
Yes, sir.
No, sorry. That is. That page number are different.
Last lines.
Sir, the running page number.
One. મારામાં સાહેબ 149 છે. મારા બંચ જે છે અપીલનો બંચમાં 149. Running page number 149. annexure ની સાથે 149 para number 10. છે જ class હા મળ્યું મળ્યું sir
Yes.
હાજી. We are afraid that this is a misreading of so and so the Madras High Court judgment. It was only on particular facts of the case that want of section 80 CPC against one defendant lead to the rejection of the plaintiff as a whole. Against one defendant lead to the judgment as a whole. Now, against one defendant lead to the rejection of the plaintiff as a whole. Now, as no cause of action would remains against other defendants. Misleading of the Madras High Court judgment. We are afraid. That is the observation. Now, sir, this cannot elevate itself into a rule of law that once a part of a plaint cannot proceed, the other part also not proceed. Again, and the plaint as a whole must be rejected under order 7 rule 11. In all such cases, now that is the finding which has trial court has not mentioned. If the plaint survives against certain defendants and certain properties and or order 7 rule 11 will have no application at all and suit as a whole must then proceed to trial. That was the observation.
Sir, now tell me the same thing. Suppose there are 10 defendants. One defendant takes an objection.
Yes, sir.
That suit is barred by
Barred by-
limitation.
Correct.
Cause of action arose in 2000, suit was filed in 2015.
Yes, sir.
So, the words used here, if plaint survives against certain defendants,
Yes.
if it is barred by limitation, it is barred against all the defendants. Or for some of the defendant, is it barred by limitation, and some of the defendant, it is within limitation.
Correct.
How is it possible?
That is why this observation was made before by Honorable
That is
Supreme
why
Court.
I am saying,
How is it possible?
it says,
As far as this
it
case is
says
concerned,
plaint survives against certain defendants.
yes,
In your case, if it is barred by limitation, it does not survive against any of the defendants. It is barred by limitation against all the
as
defendants.
far as my case is concerned, I tried my best to convince the conscience of this honorable court that with regard to the factual aspect that I am co-partner.
Sir,
And-
but you even now
and-
I am saying you did not disclose all the facts
Now I am going to disclose
because
everything.
the
Because-
issue is of limitation.
Yes, sir.
And you did not mention any of
Now-
the dates.
Now I am going because error of law prevails over error of facts.
It is based on facts only, sir.
Based on- But sir,
You yourself said it is a mixed question of law and facts.
these are error of law, and now I am coming to the facts, and that is why now I am going to read plaint only, sir, because nothing is read, only plaint and these documents. Plaint, sir, annexure D.
Page number 23. 23.
Ha. Page number 23, D, annexure D. એમાં 26 થી ચાલુ થાય છે. પેજ નંબર 26. અમો વાદીની હકીકત નીચે મુજબ છે. પેરા નંબર 1. અમો મરહુમ ચંદુજી શિવાજીના સીધી લીટીના વારસદાર છીએ. સદર બાબત વાળી જમીન વડીલો પાર્જિત હોય. સદર જમીનમાં અમારો બાય બર્થ પણ વહેંચાયેલ લાગ ભાગ હક હિસ્સો પોસાતો
Sir,
આવેલ
sir.
હતો અને છે.
Not going into the details.
Haji.
Your case is that you are co-partners.
Yes,
The property was sold
By grant.
without your consent.
without my consent.
When it was sold? On which date?
86,
81. 1981.
હા 1981, and the entry was ફરી બીજું વેચાણ થયું 86. સર એટલે જ હું પેલો પેરેગ્રાફ વાંચું છું કે પ્લેન્ટમાં સાહેબ એમાં મેં બધું લખેલું જ છે. કે certain issues are
Sir, just
issues of trial.
when the suit was filed,
Suit was filed in the year 2024.
when you came to know about this sale,
That is cause of action mentioned in para number 14 that I came to know in 2023.
how you came to know?
Yes, that was mentioned in cause of action on page number 30, running page number 30, sir. દાવાવાળી વાંચું સર
जी जी.
હા છેલ્લી 4-5 લાઈન
Of page 30.
30. કેમ કે where is that particular date is mentioned?
That is Dad Ma.
No, that is on 15, para number 15. Before that, para 14. Para 14 નો છેલ્લું 4-5 લાઈન છે કે જુદી જુદી ગાંધીનગર હા અમોને અમારા સદર જમીન પરત્વેના લાગભાગ હસ્ક હિસ્સાને નુકસાન થયેલ હોવાની જાણ થતા નામદાર પ્રાંત અધિકારી શ્રી ગાંધીનગર સમક્ષ જુદી જુદી નોંધો વિરુદ્ધ અપીલ નંબર 100/2022 સાહેબ બતાવે છે દાખલ કરેલ ત્યારથી તેમજ વાદવાળી જમીન અંગે વેચાણ લેનાર ખેડૂત ખાતેદાર ના હોય. સાહેબ વેચાણ લેનાર ખેડૂત ખાતેદાર હતા જ નહીં તે વખતે. That was the fraud committed by the other side. મામલતદાર કૃષિ પંચ દ્વારા કરાવવામાં આવેલ હુકમ 100 ની નકલ તારીખ 22/4/2023 ના રોજ પ્રાપ્ત થયેલ અને અમોવાદીની સહી મત્તા તેમજ સંમતિ વગર કરવામાં આવેલ વેચાણ દસ્તાવેજની નકલ 17/8/2023 ના રોજ મેળવતા ત્યારથી આપ નામદાર કોર્ટ સમક્ષ સદર દાવાવાળી અરજી તથા મને અરજી કરવાની જરૂર ઉપસ્થિત થઈ.
From 81 to 23.
Yes.
You were not aware.
Yes, that was my pleading, sir. That was my specific pleading.
Your
Made it-
age,
My today, sir, round about
not today, in 81.
81
Plaintiff number 2 to 5 are minor,
minor
1 and 6 are major.
major. In 21.
In
Sorry, 81.
1981.
81. એમનું એક કન્ટેન્શન લીધેલું છે સાહેબ એમ
That
એ
is the
minor
main
હતા
contention.
એમને માઇનર
Not one main
એ
contention.
એમનું કન્ટેન્શન લીધેલું છે આ મેઇન કન્ટેન્શન કહો કે વન ઓફ ધ કન્ટેન્શન્સ કહો પણ એક કન્ટેન્શન લીધેલું છે.
Who had sold?
Grandfather.
Now defendant
Grandfather
number
of plaintiffs.
Grandfather of Honorable Court. I would like to assist the Honorable Court on that the land was sold by the father of plaintiff number 1, who is the grandfather of plaintiff number 2 to 6.
2 to 6. Father
Grandfather has sold the property.
It is
Father-
land or some,
Land.
agricultural
Agricultural land.
it was sold in 1981 and 1986.
Correct,
No,
correct.
1986, there was no sale deed. In the 1981, the land was sold to the subsequent purchaser. The ground was taken that he is not an agriculturist, so entry was rejected. We went through the revenue authorities, and in the end, at the time before the GRT, my entry was passed in 1986. The entry of sale deed of 1981 was passed in 1986.
And in whose possession land is since 81?
Defendants, 6 to 9.
6 to 9 7/12 માં એમનું નામ છે.
I'm not talking about soft
Physical
power, I'm talking
possession
about
land.
Legal
possession.
possession એમનું છે અમારું નથી.
And you are living,
હું સાહેબ એક પ્લીઝ આઈ એમ સોરી.
The land was sold only once in 1981. There is no subsequent event.
એમ નથી પોઝિશન સાહેબ નથી.
since 81, possession is not with the plaintiffs.
Huh.
It is with defendant number 6 to 9.
હા
They are showing it.
હા ઓનર but
and you are living where?
Sasre, Sasre,
Where is that Sasra? In India or abroad?
Gandhinagar, Umarsad.
Umarsad.
The land situated in Umarsad. They are
That's
living
why
in
I'm asking.
Umarsad. Same village.
પણ
Disputed
So
property.
My
you are
question-
saying
my question
since 1981,
we
possession of the land is with defendants.
with defendants.
They are doing their agriculture work over the land since
Huh.
1981.
Huh.
You are living in the same area.
Huh.
You say that you are the owner and
Huh.
you did not know.
પેરા નંબર હા
How?
પેરા નંબર 12 માં સાહેબ મેં લખેલું છે પેરા નંબર 12 of the plaint on page number 20 running page number 28.
Let's go through para 8 at para 12.
20 para 8 27 page number. અમોવાદી આપ નામદાર કોર્ટને જણાવીએ છીએ કે સદર દાવાવાળી જમીન અંગે આ કામના પ્રતિવાદી નંબર 1 થી 3 નાઓ દ્વારા આ કામના પ્રતિવાદી નંબર 1 થી 4 નાઓને અમોવાદીની કોઈ પણ જાતની સંમતિ વગર 81 ના રોજ 12/5/81 ના રોજ વેચાણ દસ્તાવેજની તબદીલી કરી આપતા તે અંગેની ગામ નમૂના નંબર નોંધ પડી સાહેબ રોજ રેવન્યુ રેકર્ડ દાખલ કરવામાં આવે, પરંતુ સદર નોંધ વેચાણ રાખનાર ખેડૂત ખાતેદાર ના હોઈ નામંજૂર કરવામાં આવેલ, પરંતુ સદર નોંધ વિરુદ્ધ સામાવાળા નંબર 4 થી 8 દાવો દ્વારા સદર હુકમ વિરુદ્ધ રેવન્યુ રેકોર્ડની જોગવાઈ મુજબ સમક્ષ કોર્ટમાં અપીલ કરી અપીલ કરવાને બદલે ફરીથી રેવન્યુ રેકોર્ડની જોગવાઈ વિરુદ્ધ ફરીથી વેચાણ નોંધની તારીખ 11 સાહેબ વેચાણ થયું 81 માં, એમને ફરીથી વેચાણ નોંધ પડાઈ 86 માં. જો એ ખેડૂત જ હોત તો ત્યારે જ નોંધ પડી ગઈ હોત ને 81 માં જ.
Is that
એક
in
એક
dispute?
that is the that yes that is dispute an issue of trial.
Sir, I'm not talking about trial.
Huh.
In this appeal,
Huh.
the dispute is only the question of limitation.
But they have raised this question.
Sir, that is in suit.
No, in
The
appeal
suit has
there's
been rejected only on the ground of limitation.
limitation. But
So
they have
now the only thing to be considered is the point of limitation in this appeal.
point of limitation. But in support of point of limitation, all these facts are required to be considered, whether the fraud was committed or not. Isn't this required to be considered at this stage? And fraud has no limitation.
Who says?
Whether fraud has limitation?
I think so. If you are aware about the
When-
fraud, a fraud has
If you
been
are
played
aware-
against you.
If you are aware
And if
about
you-
the fraud, yes,
And
correct,
if
sir.
you sleep over
My-
your rights for
My lord is absolutely
good
correct.
20 or 25 years.
Need not be.
Sir, division આજ સિંગલ જજનું છે, division bench નું મારી પાસે જજમેન્ટ છે, wherein it is said that fraud vitiates all proceedings including limitations. અને સર ચિંગલવાલી સુપ્રીમ કોર્ટ નું જજમેન્ટ છે સાહેબ, આ સિંગલ બેન્ચ નું જજમેન્ટ છે, મારી જો ડિવિઝન બેન્ચ નું ગુજરાત હાઈકોર્ટ નું જજમેન્ટ છે,
દે દો sir.
હું આપી દઈશ સાહેબ. બે જજમેન્ટ છે સાહેબ ફ્રોડ વિશે, એક ગુજરાત હાઈકોર્ટ નું ડિવિઝન બેન્ચ નું અને બીજું એસપી ચિંગલવરિયા વર્સિસ જગન્નાથ ઓનરેબલ સુપ્રીમ કોર્ટ પેરા નંબર 7. એવું બંને
ये
સાહેબ
देख
હું
लेते हैं,
જજમેન્ટ
अगर वो एप्लीकेबल है तो उस पे चलेंगे.
હું આપી દઈશ સાહેબ. હું એ બંને જજમેન્ટ લઈને અત્યારે આજે મને લાગે કેમ કે એમાં મેં નતું પ્રોડ્યુસ કર્યું ને, પણ હું લઈને આવી જઈશ સાહેબ. એસપી ચંગલેવર વર્સિસ સ્ટેટ ઓફ જગન્નાથ છે, પેરા નંબર 7 છે. તેમાં તો સાહેબ એમ લખેલું છે કે થ્રો કરી દેવું જોઈએ જો ફ્રોડ માણસ કરેલું હોય ને તો. અને ડેટ ઓફ નોલેજ મને ક્યારે છે, અને ડેટ ઓફ નોલેજ ઇઝ ઓલવેઝ પ્રિવિલ ઓફ ડેટ ઓફ રજિસ્ટ્રેશન સાહેબ. ધેટ ઇઝ જજમેન્ટ ઓફ ઓનરેબલ સુપ્રીમ કોર્ટ, એ બી હું પ્રોડ્યુસ કરી નાખીશ. તો મને જ્યારે when I have specifically pleaded in my particular paragraph number 8, paragraph number 10, paragraph number 14 કે મને અહીંયાથી જાણ થઈ, મેં એમ પણ કીધું કે સાહેબ આ ખેડૂત નથી અને ગુજરાતમાં સાહેબ ખેડૂત હોવો કમ્પલસરી છે, આપ સાહેબ જાણો છો, ઇટ ઇઝ મેન્ડેટરી. હજી સુધી એવો કોઈ કાયદો નથી આવ્યો કે ખેડૂત ના હોય તો ચાલે એગ્રીકલ્ચર લેન્ડ માટે. અમિતાભ બચ્ચનને બી સાહેબ નથી મળી. તો આ લોકોને કેવી રીતે મળી? અને ફ્રોડ નું એસપી ચિંગલવારિયા વર્સિસ સ્ટેટ ઓફ જગન્નાથ જે પેરા નંબર 7 જે છે સુપ્રીમ કોર્ટ નું જજમેન્ટ છે બહુ જ ક્લિયર છે અને રિલાઇંગ અપોન દેર આર નંબર ઓફ જજમેન્ટ્સ આર રિલાઇંગ અપોન ધેટ પર્ટિક્યુલર જજમેન્ટ ઓનરેબલ ડિવિઝન બેન્ચ જસ્ટિસ આપણા ચીફ જસ્ટિસ સાહેબ સુનિતા મેડમ તેમને એ અત્યારે કીધું છે એ જજમેન્ટ છે મારી પાસે હું સાહેબ હું લેતો આવીશ કાલે પરમ દિવસે તમારી હા તો સાહેબ ડે આફ્ટર ટુમોરો રાખીએ ડે આફ્ટર ટુમોરો રાખીશું કારણ કે મારું પતિ જશે પછી એમનું ચાલુ થશે ને એટલા માટે મારી રિક્વેસ્ટ છે ડે આફ્ટર ટુમોરો માટે કાલે હું બહાર છું એટલા માટે મારે અહીંયા પતાઈને બહાર જવાનું છે એટલે
कितना टाइम लोगे सर? अभी लंबा है आपका? और
થોડાક સાહેब આ ખાલી ફેક્ટ્સ
थोड़ा तो एक ही दिन में हो जाएगा ना इनका भी साथ ही.
હા તો થઈ જશે એ દિવસ
Half an hour is required for all this.
Just one or two citations, that's it.
हाँ तो
That one Prem Singh versus Birbal.
हम सब प्रेम सिंह
that half an hour is not required, I'm saying.
That is what I'm saying, the maximum
Just
time
clear
that I
to the
take.
basic facts.
These
You
are the
need not do that.
basic facts. I
You
need
need
to
not
show
do
the
that.
in the factual aspect, I need to show the age of plaintiffs.
That is in the plaint itself. 64 now. 2024 it is 64. Okay, day after tomorrow.
Please.
day after tomorrow sir it's
Second half, first
second half subject to the convenience sir of this honorable court.
Okay.
3 વાગે sir
Try કરીશું પર
ના ના
સાક્ષી હશે તો third second half.
ના એવું એક નક્કી કરી નાખ્યું. એટલે
કહી ના શકાય કે સાક્ષી આવશે કે નહીં આવે.
સાહેબ ને જે અનુકૂળતા હોય સાહેબ આપને ડે આફ્ટર ટુમોરો એટ 3 o'clock આપને અનુકૂળતા પ્રમાણે
સર મને તો 11 વાગે પણ અનુકૂળ છે.
મેં કીધું
સબ્જેક્ટ ટુ સાક્ષી.
સબ્જેક્ટ ટુ સાક્ષી એટલે
સાક્ષી એન્ડ બેલ.
તો એ બધું સાહેબ પતી જાય કેમ કે આજે સવારે જે મેં જોયું ને બપોરે જોયું તો કાલ પરમ દિવસ જે રાખ્યું છે એ પૂરું થઈ જશે સવારે એટલે બપોર પછી સાહેબ 3 વાગે ઇટ્સ માય હમ્બલ ઓબ્લાસ આઈ એમ ડીપલી ઓબ્લાસ
સિરિયલ નંબર 4 માં સાહેબ સમાધાન માટેનું આપેલું હતું ઓરિજિનલ કમ્પ્લેન્ટ પેલો જે પૈસા ઉપાડવા માટેની એપ્લિકેશન
वो तो हो जाएगा सर, वो उसका तो इशू नहीं है कोई.
આધાર કાર્ડની ઝેરોક્સ બાકી
मेन तो वो डिपॉजिट का है. ऐसे आप किस में ब्रह्मट साहब बताइए तब तक.
सब सिविल में सीरियल नंबर 35 आरसी 1223 एमा समाड़ा तरफे सर
सुबह से कोई भी नहीं आया इसमें.
मैं आया था सब 2 बार लेकिन ट्रायल चल रहे थे इसलिए
सर सारा दिन कुछ ना कुछ तो चलेगा, थोड़ी तो वेट किया करो.
नहीं वेट किया है सर
हाँ करते हो आप, इतनी जल्दी में रहते हो.
नहीं सर
14/9.
जी ऑब्वियस है
हाँ जी.
बिल एप्लीकेशन 1146 ऊपर इसमें बिल देने के लिए तो नीचे से मंगाने का
हाँ जी जगना मैम आपकी जामीन अर्जी थी एक. हाँ जी.
इंटरेस्ट बिल है सर उसकी वाइफ प्रेग्नेंट है सर और उनके वकील ने अभी बोला कि उसको कल बच्चा भी हुआ है, लड़का आया है, इसके हिसाब से उन्होंने किया है सर. लेकिन उनके रेगुलर जामीन 2 बार यहाँ से रिजेक्ट हो गई है और हाई कोर्ट से भी रिजेक्ट हो गई है सर.
जामीन अर्जी हाई कोर्ट तक रिजेक्ट हो गई. एविडेंस अभी पेंडिंग है केस में.
जी
मर्डर केस है.
मर्डर केस है
क्या
सब
करें?
दिक्कत वाली बात है सर. मैं तो सर
कितने दिन
सूरत
मांग रहा है?
30 दिन की मांगा है सर.
30 दिन किस लिए?
पता नहीं वो तो अंदर से भी
वो तो डिलीवरी से पहले की बात है ना, अभी तो हो गई डिलीवरी.
हाँ हो गई.
अभी 30 दिन किस लिए?
इसमें तो हो गया ऐसा नहीं लिखा है क्योंकि कल ही बच्चा आया है.
विद जाब्ता जितनी चाहिए बोलो.
फिर जाप्ता
उसके बिना नहीं
तो जाप्ता की जो फिर उसको
तो भरना
मेंटेन
पड़ेंगे ना.
हाँ मेंटेन करना पड़ेगा ना सर. तो उसके पास तो पैसा ही नहीं है कुछ।
फिर कैसे करें?
कैसे करे सर? कल जाती हूँ जेल पर, पूछ लेते या फिर बोल दे, तो फिर एक डेट रख दो सर।
ठीक है, कब रखूं बोलो?
कल,
31st?
हाँ 31st या सर, ठीक है।
कल आप जाओगे तो फिर
कल मैं
परसों ही
जाऊंगी तो कल तो,
परसों ही रखो।
हाँ परसों ही रखो सर।
ठीक है, हाँ जी सर।
મારી રિક્વેસ્ટ એવી હતી
હા.
કે આ જે આરોપી ખરા ને એમના જે ત્યાં નોકરી કરી છે ને ત્યાં એનો પગાર કાપી લીધેલો છે, 3 પગાર કાપી લીધેલા છે,
હમ.
25,000 અને 5,000 રૂપિયા દંડે કરેલો છે એમના. અને સગા સંબંધીમાંથી સાહેબ પગા પાછા કરી અને 4 લાખ નામદાર કોર્ટમાં જમા કરાયેલા છે. તો નામદાર કોર્ટને એવી રિક્વેસ્ટ છે કે એમની વાઈફની એ દવા ચાલે છે ઘણા સમય, સાહેબ રિઝનેબલ એમાઉન્ટ
सर मैंने थोड़ी फिक्स किया है उसमें कुछ भी
नहीं.
मैंने तो एक पैसा भी नहीं कहा उसमें।
ओके.
जो सुप्रीम कोर्ट की जजमेंट है वो है, उसमें मैं क्या करूं?
इसमें सर थोड़ा बार्गेनिंग होता है।
बार्गेनिंग नहीं होती सर कोर्ट में।
नहीं नहीं 5% कर दो तो कोई
शाकभाजी मार्केट नहीं है, कोर्ट है।
नहीं 5% कर दो तो सर मैं उसको पूछ के बराबर करवा देता
सर उसमें 7.5 तक ही है, वही करिए।
हूँ। गवर्नमेंट एम्प्लॉय और पैसे की बहुत दिक्कत है, इसलिए तो।
गवर्नमेंट एम्प्लॉय है
लेकिन इसमें
और एम्प्लॉयर ने पगार काट ली है।
हाँ
कैसे?
इस हिसाब से ये केस हुआ ना, इस सजा हुआ है। हाँ साहब वो ऑर्डर
क्या काम करता है?
कई जगह नौकरी करो सर। मैं SRB ग्रुप 12 में सेनापति श्री पी मनोहर साहब है।
आप क्या हो वो बताओ, उनको छोड़ो सेनापति को।
તમારો હોદ્દો કયો? મારો PSC हेड कांस्टेबल। એમાં સાહેબ પગાર કાપેલો છે ને, આમાં 5,000 રૂપિયા દંડ કરેલો છે 3 મહિના. 3 મહિના એગ્રીમેન્ટ બંધ. અને આ સાહેબ પ્રાઇવેટ મેટર છે, 5,000 રૂપિયા દંડ ટેક રિટર્ન. અને સત્ય એમને
उसमें मैं तो नहीं कुछ भी उनको कह सकता सर।
मैं सब ये इसीलिए बोल रहा हूँ कि सब रीजनेबल
रीजनेबल में क्या होता है इसमें?
थोड़ा सा कुछ करो
जो सुप्रीम कोर्ट कह रही है रीजनेबल
इसीलिए
कह
तो
रही है
हमने
सर।
प्राइवेट वकील नहीं रोका साहब।
सुप्रीम
legal
कोर्ट
में से-
अनरीजनेबल बात तो नहीं करती। जो सुप्रीम कोर्ट ने कहा रीजनेबल है।
5% संबंधी
सॉरी सर,
10% है तो 7.5 होता है, तो सब मैं बोल रहा हूँ 5%।
10 से तो 7.5 होता है, मतलब 7.5 ही है जजमेंट में। जजमेंट में लिखा है 7.5%।
અમનું કેવું એવું તો જો તમે રજૂઆત કરો છો નામદાર કોર્ટમાં તો સાહેબ તમારે કે આજે 4 લાખ ભર્યા છે
सर
ને।
जजमेंट में ही स्टेज वाइज है। अगर आप ट्रायल कोर्ट में करते तो कम था, अपील में आ गए तो 7.5 है।
मैं अभी एक हाईकोर्ट में क्वेश्चन किया तो 1 रुपया भी नहीं किया।
सर हाईकोर्ट के पावर्स अलग हैं, मैं थोड़ी उतने कर सकता हूँ कुछ।
1 रुपया नहीं किया।
हाईकोर्ट की पावर्स और मेरी पावर्स बहुत डिफरेंस है सर। मेरी कोई औकात नहीं है हाईकोर्ट के पावर्स के आगे।
साहब 30,000 रुपया आज लाएला नहीं तो साहब टाइम थोड़ा।
कब लाओगे बोलो, कल ले आओ।
एक हफ्ता
1 हफ्ते में ले आओ।
मैं एप्लीकेशन
उतना मेरी डिस्क्रिप्शन है वो मैं कर सकता हूँ।
नहीं या तो उन्होंने बोला कि सर नामदार को तो सब रिक्वेस्ट करते हो तो सब।
सर टाइम का मैं कह सकता हूँ 1 हफ्ता, वो कोई इशू नहीं है। हाँ, ठीक है, 6 बजे को। ठीक है।
अरे अभी आपकी जी शेव मारो ना
मार दीजिए। 6-8
अपना भाई
ના વ્હાઈટ જ હા ચેકથી જ 6-8 વિડ્રો કરવાની
हाँ हाँ आगे चेक कर दीजिए।
उसका क्या मैटर जैसे
6 तारीखे पैसा जमा करे પછી વિથડ્રો
ऑब्लाइक्स अच्छा
6-8
जी सर, आप लोग किसमें?
ડિપોઝિટની રકમ જમા કરાવી છે એની અરજી આપી છે કામ લેવા માટે।
जी राहुल साहब कुछ और था बाकी? उसमें जो आप कह रहे थे वो इंटरिम वाले वो परम देश से रखिए।
हाँ
मैंने कहा पूछ लो, जब तक के साथ चाहिए तो जितने चाहिए दिन चाहिए बोलो।
और सर मैं तो आपको जो थोड़ी तरह मैंने मुझे तो आपसे कहना है इसका भाई ये छुट्टी आने के बाद नया करेगा घर में ही है, वैसे तो हम बोलते हैं पड़ोस में है, मोहल्ला में है, गांव का है।
सर बाकी तो कुछ करे या ना करे, बट उसी की वकील ने ये दलील की थी कि ये मर्डर इसने नहीं किया, चोरी करता है, मैं मानती हूँ। मैं कैसे कैसे चोरी करने के लिए छोड़ू?
किसी आरोपी ने आज तक बोला है सर कोर्ट में?
नहीं, पर चोरी एडमिट किया था कि चोर है, चोरी करता था।
वो तो बड़ा किया इसलिए चोरी में भी कोर्ट में जाके पूछोगे एडमिट किया
चोरी करने के लिए कैसे उसे छोड़ दूं?
कोर्ट में चोरी का केस है वहां भी एडमिट किया है देखो इतिहास पता चले कोई आरोपी कैसे बोलेगा।
क्या था इसमें? पासपोर्ट था, पासपोर्ट आ गया वापस। पासपोर्ट टाइम पे क्यों नहीं जमा किया?
25 तारीख को गए थे तो वो बंदोबस्त था पुलिस वाले का, तपास
वहाँ पुलिस स्टेशन में करना था।
हाँ जी सर,
पुलिस स्टेशन में
हाँ
जमा?
पुलिस स्टेशन में करना था। उन्होंने बोला कि सोमवार के दिन आप आके जमा करवाओ, वो बंदोबस्त में थे तपास अधिकारी, तो मैंने अंदर मेंशन भी किया है सर।
जीरो सोते मैंने कभी किया नहीं लाइफ में। कर दिया सर। राजेश। एक नंबर करो, कभी जीरो कम कभी एक कम।